State's ready, Your Honor.
Yes, Your Honor.
It's going to be State of Florida versus Noah Christopher Brake, 2026 CF 151. We're here for a pretrial detention hearing. Ms. Glisson, is the state going forward with pretrial detention?
We are, Your Honor.
All right, and I've previously reviewed the motion. Mr. Kleins, anything that you want to add before we get started?
No, Your Honor. I talked with Ms. Glisson before it started, and my understanding is she's going to call one witness. So if there was going to be multiple witnesses, I was going to ask to invoke the rule, quite frankly, but if it's just one witness, I'll turn it over.
Okay.
Your Honor, before I call that witness, if I could offer State's Exhibit 1 into evidence, which is the offense report and the witness statements, which were attached to the state's motion, in addition to a 2-page victim statement that has been written since that motion was filed. I have shown forwarded Mr. Kleins a copy of that.
And I did review the witness statement, Your Honor, that Ms. Glisson forwarded to me. On this particular exhibit, the defense will object to lack of foundation, but I'll turn it over to Ms. Glisson to respond.
And hearsay is admissible, Your Honor, for purposes of pretrial detention.
I think his objection was foundation.
Found it. I can authenticate it. I guess I can put the officer on the stand and ask her if this is part of her case file. I will authenticate it through her.
Is that a second witness?
No, Your Honor.
I just want to know if Mr. Klein just want to invoke the rule if there's a second witness.
There's just one witness.
Okay.
There's just one witness. In reviewing the police report, it's a compilation of different witnesses. I mean, different officers are writing supplements that are included here. So the objection would go to the foundation for every one of their police reports. So if the officer who is testifying wants to authenticate that officer's supplement, okay, but the lack of foundation would apply to the other officers' written reports.
Listen.
Well, if hearsay is admissible, Your Honor, I could have the officer just read from those statements, because for purposes of this hearing, hearsay is in fact admissible. So however the court prefers me to do it.
I haven't reviewed the particular packet that you've got, but I'll have you introduce it during your witness's
Okay.
testimony, and we'll take it from there.
Yes, Your Honor. Okay. There is no objection from defense for State's Exhibit 2A. There's going to be 2A, B, and C, and D. It is for Google Earth maps that the state has filed judicial notice of on January 20th of 2026. And so there is no objection to that?
There is no objection, Your Honor.
Okay.
Okay.
Those will be admitted without objection.
And State's Exhibit 3, there's also no objection from what I understand?
That is correct.
This is going to be a photograph that was taken of the crime scene.
Without objection, Exhibit 3 will be admitted.
Thank you. And the state would call Caitlin Walters. Or Walter, sorry.
Walter. Raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Please make sure you speak into that microphone. Just as a kind of a addition, I understand you filed these things with the motion. I typically don't like to read the exhibits to motions unless there's either they've been admitted or I know there's no objection, so that's why I don't go through those things and haven't reviewed that packet before today. All right, go ahead with your questions, Ms. Glisson.
Good afternoon, Investigator Walter. Could you please state and spell your first and last name for the record?
Yep, my first name is Caitlin, K-A-T-E-L-A-N-D. Last name is W-A-L-T-E-R.
Where are you currently employed?
The Crestview Police Department,
How long have you been employed there?
just over 2 years.
Okay, and what is your position or your title?
I'm an investigator.
How are you involved in this case?
I was the on-call investigator at the time of the incident.
Okay. And did Crestview Police Department respond to a call for service at 264 Swaying Pine Court in Crestview, Florida on January 10th of 2026?
Yes,
And approximately what time did they receive that call for service?
just after 10 p.m.,
What was that call for service regarding?
a shots fired.
And once Crestview Police Department arrived on the scene, what was observed? What was going on?
There was a victim who sustained several gunshot wounds out front of the residence.
The victim was out in front of the residence?
Yes.
Was the alleged shooter still on scene when Crestview arrived?
No.
Were you able to determine whose house this shooting occurred at?
Yes.
Whose house was that?
The witness/victim, Duran Carpenter.
And that's a female?
That's a female, yes. As well as the defendant's Noah Brake.
And they lived at that house
They did, yes.
together? Did they own that house or rent that house together?
I believe they rent the house.
Were you able to determine how the defendant and Mrs. Duran Carpenter knew each other?
They were involved in a relationship.
And throughout your investigation, did you direct others to collect written statements? Did you collect written statements from witnesses in this case, your other coworkers, and Bay County Sheriff's Office?
So officers prior to my arrival collected witness statements. And then I collected a victim statement a few days ago.
And all of the statements that have been collected for this case, you are in control of that case file?
Yes.
Okay. May I approach, Your Honor? I'm going to show you what's marked for State's Identification 1. If you could please just scroll through those documents there. Do you recognize those documents?
Yes.
How do you recognize them?
They are the incident report between Crestview Police Department, Bay County Sheriff's Office.
Okay, and are all of these reports and witness statements in relation to your Crestview case, which you're the lead of, which is what we're here for today?
Yes.
Okay, other than social security numbers being redacted and children's names being redacted, do these materials depict information that has been provided to you throughout your investigation?
Yes.
All right. Your Honor, at this time, I'd offer State's Exhibit 1 as evidence.
All right, Mr. Kleins.
Renew the objection, Your Honor, especially as it goes to these witness statements. Unless the officer was present when the statements were given, it still doesn't fix the authentication issues.
Okay, if I could take a look at it so I know what we're dealing with, but I will point out Florida Statute 907.041, paragraph 5, subparagraph I, which is related to pretrial detention hearings, says the rules concerning admissibility of evidence in criminal trials do not apply to the presentation and consideration of evidence at the detention hearing. The court may base an order of pretrial detention under paragraph D solely on hearsay. And then there's a section of evidence secured in violation of the United States Constitution or the Constitution of the state of Florida shall not be admissible. So I'm not even sure a foundation argument can be sustained at this point based on it, but I'm going to take a look at it, Mr. Kleins.
I mean, just so the court's aware, like, what we're talking about is the state of Florida is abrogating a constitutional right with a statute and a rule of procedure. I mean, everybody in the state of Florida has a constitutional right to a bond. And so it startled me when I first read that they would actually put into a statute that the rules of evidence flat out don't apply in a situation where somebody's constitutional right might be taken. So I know what the rule says, I know what the statute says.
Well, what does the Constitution say about it then, Mr. Kleins, as far as release? If someone's charged with such a crime,
Well,
are they entitled to a bond under the Florida Constitution?
under the Florida Constitution, they are, unless the facts, I'm trying to think of the language, it's been a minute since proof is evident. But I mean, even then, I mean, we're talking about that language, we're talking about proof beyond a reasonable doubt. I mean, it's the height, that's the pinnacle of the burden of proof here. but it's the I cannot remember the language off the top of my head right now. But yes, there is a way that the constitutional right can be abrogated, but it depends on the strength of the evidence.
Let me review the exhibit. And just to put it on the record, I believe Mr. Klein's what you're referring to is the Florida Constitution, Article 1, Section 14, sometimes often referred to as an Arthur hearing is what we talk about as unless charged with a capital offense or an offense punishable by life imprisonment and the proof of guilt is evident or the presumption is great. Every person charged with a crime or violation of municipal or county ordinance shall be entitled to pretrial release on reasonable conditions. If no conditions of release can reasonably protect the community from risk of physical harm to persons, assure the presence of the accused at trial, or assure the integrity of the judicial process, the accused may be detained. All right, any further argument, Mr. Kleins?
No.
Anything else from the state?
No, Your Honor.
State's Exhibit 1 will be admitted. I will note it is primarily hearsay. Again, the statute that I've previously read, as well as the rule of procedure on pretrial detention. And that's going to be 3.132 L3 states, L2 states the order may be based solely on hearsay, but must be based solely upon the evidence introduced at the hearing and must be supported by findings of fact and conclusions of law.
Thank you, Your Honor. May I continue?
Yes, go ahead.
Investigator Walter, you said the shooting occurred at 264 Swaying Pine Court in Crestview, Florida. Is that right?
Yes.
All right, so already introduced into evidence is State's Exhibit 2, and that is going to be some Google Earth images. Have you had the opportunity to review those images prior to testifying today?
Yes.
Okay, so I'm now going to publish with permission from the court, Exhibit 2A, if I may, Your Honor,
Yes.
publish to the projector, please. And for reference, I would just like to have you confirm an aerial view of where the location was.
It's on, it's just turn it on the screen, there it goes.
Is this a neighborhood of homes or townhomes, apartments? What is this that we see here?
It's a neighborhood of townhomes.
Okay, so for purposes of this hearing, do you see, it is pin marked, but do you see where 264 Swaying Pine Court is located?
Yes.
Okay, is that the pin mark we see right here?
Yes.
So it's kind of at the end or at the back of this townhome community, is that right?
Yes.
So State's Exhibit 2B, what view is that showing you?
That's going to be the view of the front of the residence, the building.
Okay, 264, is that over here?
Yes.
And showing you 2C, what view is this showing you? Just in the neighborhood?
Yeah, that's,
And what about 2D?
that's also the neighborhood.
Would you say this is a pretty heavily populated neighborhood?
Yes.
Now, were you able to learn that several witnesses were present on scene when the shooting happened?
Yes.
Were those witnesses interviewed?
Yes.
Take me through what you learned during your investigation as it relates to the shooting that occurred January 10th between Mrs. Carpenter and the defendant. What kind of led up to that, to the shooting of the victim, by Noah Brake?
The Duran was removing items from the residence.
Why was she removing her items from that residence?
I guess the defendant and Duran were having a falling out, and so she was removing her items to leave.
Okay, when was that falling out?
I'm not sure the exact date, but January 10th is when she was packing her items.
Okay, so Ms. Carpenter and the defendant were breaking up,
Yes.
going their separate ways? Okay, so after the falling out that morning, what happened?
She got assistance from some people to help remove her items. And while she was packing those items, the defendant showed up and approached the garage door that she was at with the victim.
Okay, let me stop you right there. So Duran's moving her stuff out. She calls people to help her move her stuff out of the house.
Yes.
Did you learn that the defendant had taken some of Ms. Carpenter's property
Yes.
earlier in that day?
Yes.
What was taken?
Duran's cell phone, a tablet, and a tan Glock firearm.
Was there any special characteristics of that tan firearm that belonged to Ms. Carpenter?
It had a green laser on it.
When did Ms. Carpenter tell you that the defendant took those items?
He took them the morning of the 10th.
And then after he took those items, what did the defendant do?
He left.
So while the defendant is away from the home, that's when Ms. Carpenter is having her friends and family come and help her move out?
Yes.
Okay. Now, was the victim, Dustin Wooten, was he one of the ones that was helping Ms. Carpenter move out of the home?
Yes.
And who was he there with?
Her mother, Fontaine.
At the request of Ms. Carpenter?
The request of Ms. Fontaine.
Okay. And did the defendant eventually return to that home the same evening?
Yes.
Do you know about what time?
Just shortly prior to the 911 call coming out,
And the 911 call came out at what time?
just after 10
PM.
p.m., yes.
So when the defendant pulled up to the house, where did he park?
He parked, if you're looking at the residence, he parked towards the right side.
Okay. Let me, if I may, Your Honor, publish State's Exhibit 3, which has already been entered into evidence.
Go ahead.
What does this photograph depict?
The front of the residence.
And this vehicle, can you use that vehicle to kind of guide us, to show us where the defendant parked whenever he arrived home that night?
The defendant's vehicle was parked more towards the street.
Would it be over on this side?
Yeah, it's going to be on the right side, just further down from that vehicle.
So whenever the defendant pulled up in his vehicle, who was in the car with the defendant at the time?
2 children, Ava and Carter,
Okay, and how old did you learn those children to be approximately?
5 and 6,
Where were those kids at in the vehicle?
in the backseat.
Anyone else in the vehicle with the defendant?
No.
So when the defendant pulled up to the home, he parks with the children around this area in front of the home. Who was outside at that time in front of this townhouse?
Duran, as well as the victim, Dustin.
Okay. And when the defendant got out of the car, what happened?
He approached Duran,
Who's he?
the defendant, and put his hand out. Duran asked for her items back, and the defendant began walking away. The victim asked if the defendant was going to give Duran her items. And that's when he turned around and produced the tan Glock firearm.
So after that exchange of words regarding return of property, the defendant was walking away, and the victim asked the defendant, "Are you going to return her property?" He turned around, and then what did he do?
He pointed the firearm at the victim and activated the green laser, which landed on the victim's chest.
What did the victim do once that firearm was pointed at him and that laser was on his chest?
He put his hands in the air and said, "Whoa."
Okay. And at any time, was the victim armed with a firearm or a weapon?
No.
At any time, did anyone hear any threats made by the victim to the defendant?
No.
Did the defendant, Noah Brake, shoot the victim?
Yes.
How many times?
7.
Approximately how far away from the victim was the defendant when those shots were fired?
Approximately 6 to 7 feet.
Which direction were the gunshots being fired towards?
The residence.
Where was Ms. Carpenter standing during the shooting?
At the garage door.
And after the shooting occurred, what did the defendant do?
He fled.
Were the kids still in the car?
Yes.
What did the victim do?
He fell to the ground because he was unable to walk.
And was the victim eventually taken to Fort Walton Beach Medical Center?
Yes.
Did he have to go and undergo emergency surgery?
Yes.
Have you had the opportunity to learn how many times or what the victim's injuries were other than being shot 7 times? Did he have any other significant injuries that you know of?
Yes. He is now in a colonoscopy bag.
Okay. Was the victim shot out of those 7 times? Was he shot in the back of his body at all?
Yes.
Once the defendant fled from the scene from Crestview, where was he eventually located?
At 1905 West 17th Street in Panama City.
How many miles away was he located from where the shooting occurred?
Approximately 88 miles.
And he was located the next day after the shooting?
Yes, just after 2 in the morning.
And that's in Bay County where he was located?
Yes.
What type of efforts did Bay County Sheriff's Office have to put forth in order to find this defendant after he fled?
Bay County utilized the flock system to track the vehicle. They contacted Toyota and used the GPS tracking as well as a helicopter.
A helicopter as well?
Yes.
Okay. And once the defendant was apprehended by Bay County, were the children located?
They were.
And did the defendant make any statements about where the children were located?
The defendant told Bay County that the children were located at grandmother's house at 111 Martin.
And were the children there?
No,
Where were the children?
with the defendant.
Did the defendant make any spontaneous statements to the deputies regarding the whereabouts of the firearm?
He stated he threw the firearm out the window.
Was the firearm actually located in his vehicle?
Yes.
Where was that firearm located?
The firearm was located in the trunk of the vehicle under the liner where the spare tire would sit.
Under the liner that you lift up in the back?
Yes.
Okay. Did that firearm that was located in his vehicle match the description of the firearm that was stolen from Mrs. Carpenter earlier the day before?
Yes.
And did that firearm match the description of the witnesses that described the gun that was used by the defendant to shoot the victim?
Yes.
How were you able to determine, that was the same description that was given as being the murder or the attempted murder weapon?
There was a Glock case that had Duran Carpenter's name on the paperwork inside, as well as the green laser was attached to the firearm.
Okay. And regarding the green laser, did you have an opportunity to speak with the victim about the relevance of that laser? Where the laser was pointed at him?
Yes,
Where did he say that laser was pointed at him before he was shot?
on his chest.
And while he was being shot, did the victim describe to you what he was doing?
Yes, he was trying to run away and jumping in the air.
Was Ms. Carpenter's iPad and her phone located?
They were not. Or her iPad was located, yes.
I don't have any other questions, Your Honor.
Cross, Mr. Clones?
May I approach with the exhibits?
Yes, please. There's one that's still on.
No, I'm good. So, investigator, how much of what you just testified to was information that you learned from other people?
All of it.
Okay. So you don't have any personal knowledge of what happened at this scene?
Minus the victim's statements during his interview.
Correct. And did you personally interview that victim?
I did.
Okay. Do you know if Mr. Brake called the Crestview Police Department before he was arrested?
He did.
Okay. Are you aware of where he's from?
What do you, like where he lives?
Are you aware of his prior record?
No, not at the time of the call, I wasn't.
Okay. Did you ever confirm whether or not Mr. Brake may have been a resident of Bay County at some point?
His vehicle was registered to a Bay County address.
Okay, so once he left the scene, he went back to where he's from. Is that fair to say?
Yeah.
Okay. If I could have a second, Your Honor. Investigator, do you know who these two children were? Like, who's the parents of these children?
They are the defendant's sister's children
Do you know where the defendant's sister lives?
in Panama City.
Okay, so Mr. Brake took the kids back home to the mother? I mean, is that how you take it to be?
I don't know.
Okay. I don't have any other questions for this witness, Your Honor.
Nothing else from the
Nothing
state,
else.
Your Honor.
You can take your seat. Thank you. Any other evidence?
Nothing from the state.
Okay. Argument?
This argument, Your Honor. May I proceed, Your Honor? Your Honor, the state has filed an information in this case. So currently, he's charged with 2 dangerous crimes pursuant to 907.041. Attempted first-degree murder is a life felony, is classified as a dangerous crime, and aggravated battery with a firearm is a second-degree felony, classified as a dangerous crime as well. When looking at the 4-prong test, that satisfies the first prong, that the defendant is charged with a dangerous crime. Is there a substantial probability that the defendant committed the crime? Yes. We've heard from the lead investigator that several witnesses saw this event. The victim was unarmed. He was shot not once, not twice, not 3, 4, 5, 6, but 7 times. 7 times he was shot. There was testimony that he fled the scene, which state would argue goes to show consciousness of guilt. The firearm that there was testimony said that was used with a particular green laser, that was a Glock, was located in the trunk of the vehicle, concealed under the compartment there that holds the spare tire. The defendant made statements that he threw the firearm out, which was not true because the firearm was located. There was also children in the car that was testified to. So what we have here is we have a crime scene that happened outside of a busy neighborhood, and we have several witnesses that have testified to this. So the state would argue that there is a substantial probability that the defendant did commit the crime, both of aggravated battery with a firearm as well as attempted murder with a firearm. He was also shot in the back. The third prong is, do the factual circumstances of the crime indicate a disregard for the safety of the community? That is one reason I wanted to publish the Google Earth images to show how populated this area was. So not only was this victim shot multiple times, a very, very short distance of where 2 children were in a vehicle. It's extremely concerning that the defendant did so in such a heavily populated area in the direction of other people's homes. It's the state's position that the specific facts of this case are very distressing. The fact that he decided to pull a firearm, point the firearm, and pull the trigger 7 times. So the state would argue that certainly indicates a disregard for human life and a disregard for the safety of the community at large. Lastly, there are no conditions of release reasonably sufficient to protect the community from risk of physical harm, assure the presence of the accused at trial, or ensure the integrity of the judicial process. Considering he fled to Bay County after the shooting, there was a substantial effort that Bay County had to offer in order to locate him. There was a helicopter, there was flock cameras, there was Toyota linking into the actual vehicle's GPS to show the officers where he was. That's very concerning to the state because if he is allowed on bond, the state is concerned that if he does commit another crime, he will flee again, and he will try to be less than truthful with officers. You know, for example, he told the officers he threw the firearm out the window, and that's not true. There was no firearm thrown out the window. So there's specific concerns the state has regarding his propensity to continue to engage in dangerous behavior and then flee the jurisdiction. Additionally, although the defendant, he's only 22 years old, but he has accumulated a criminal history, which includes possession of a firearm by a convicted delinquent, which means he wasn't even supposed to have a firearm in the first place here when this happened. He's been convicted of that. He's been convicted of grand theft auto, criminal mischief, and several counts of resisting an officer without violence. He's also violated his probation in the past out of Bay County, and that shows us that he is not amenable to supervision, and it shows us he's not willing to follow the court orders. So based upon the 907.041 and Rule 3.132, the state would ask this court to hold this defendant on pretrial detention with zero bond for those two dangerous crimes, because he's shown us that he has no concern for the safety of this community, and he has no concern for this victim that he shot 7 times and luckily didn't kill him. So for that reason, the state would ask for the motion for pretrial detention be granted, and the other counts in the information, the state would ask that the court set a bond as appropriate, and leave the discretion of the court. We would also ask that no contact with Dustin Wooten be imposed, or those children. Because even though those children were unharmed, there was a shooting that occurred just feet away from where those children were, and he fled with those children, lied about their whereabouts of where they were. I'm also asking for no contact with Duran Carpenter, who is his ex-girlfriend, and no return to the scene at 264 Swing Pine Circle. Thank you.
Before you start arguing, Mr. Kleins, I want to put one more thing on the record. It just came to me as Ms. Glisson was speaking. I was the duty judge the week of this incident. I'm the one that signed the arrest warrant. It was either a Saturday or Sunday morning, very early in the morning. I was awoken by the duty phone. I do recall it now because I had first appearance that morning. I know that's why I know it was a weekend. I don't recall anything about the facts of the affidavit other than what's been talked about here today. I just, again, out of transparency, I want to make sure you all understand that I previously had signed that warrant and was told that he was in Bay County at the time. That's the only thing I recall from it. But if you have any questions about that or want to raise any other issues, Mr. Kleins.
I'm good.
I know. I just want to make sure I bring it up because I just recalled it while Ms. Glisson was arguing.
Certainly. We can start there, though. We can start in Bay County. You know, the state is making this seem like Mr. Brake got in his car, fled. I mean, the word fled was used multiple times. Meanwhile, that's where his car is registered. That's where he's from. His priors are from Bay County. Like, those children, their mother is in Bay County. Mr. Brake, the investigator, conceded. He contacted the Crestview Police Department while he was being wanted. I mean, this is not a situation where Mr. Brake is openly basically getting caught on a boat trying to get across the way to the Bahamas here. I mean, he was in Bay County because that's where he's from, you know? And so I take major issue with the state trying to imply that he was trying to flee responsibility for what's going on here. A person attempting to flee does not contact law enforcement. That kind of goes against the entire concept of attempting to evade law enforcement. So this idea that Mr. Brake totally fled the jurisdiction and was doing everything he could to hide out is just not fitting with the facts of what has been introduced here today. In addition, the state is making it sound like it took multi-jurisdictional cooperation here with all sorts of things. Flock cameras already exist. They're being used every single day. To imply that that was some kind of, you know, massive burden on law enforcement, they are checking flock cameras frequently. So we definitely take issue with the idea that Mr. Brake was attempting to evade responsibility here. Mr. Brake has a totally different version of what happened. I'm assuming there's going to be a stand your ground motion at some point. But everything the court heard today, everything is basically hearsay. The investigator admitted it. She doesn't have any personal knowledge of anything she testified about, other than the witness statements that she reviewed. But that's the issue that I have with this procedure here is there is a constitutional right in Florida to bond, and it is being abrogated by a statute. So, and that statute specifically says, oh, by the way, there's no rules of evidence in this particular environment. That, I don't understand how that is a legal possibility. It is what it is, but I think the court should absolutely look into the fact or consider the fact that everything you heard today is hearsay. And there's a reason why. I was just going through the jury instructions. Years ago, I know there was an instruction just for hearsay. And it was that you have been exposed to hearsay in this trial, and here's why we have problems with it. The entire concept of hearsay goes to reliability of the information being received. I mean, that's the entire reason that the excited utterance is an 803 exception, because it goes to, okay, well, the person wouldn't have time to make something up, so you can trust what they said, you know? And so that is why hearsay is a problem, is because it comes with concerns that everybody in the system is aware of reliability. And so that is why we believe that the court should not order pretrial detention in this particular matter. I would ask the court to set a $500,000 cash or professional bond on count 1, a $50,000 cash or professional bond on count 2, and $5,000 cash or professional bonds on all of the remaining counts.
Anything else from the state, Ms. Glisson?
No, Your Honor.
All right. I'll first kind of address Mr. Klein's argument, because I think I understand what you're saying, and I say this kind of for everyone to understand. But Mr. Klein's, I don't think you were in my division yet when this change happened, or certainly the rule change, which is 3.132, based on the statute change. And the reason I bring that up is there was a very lengthy report written by I'm forgetting the name, but the Criminal Rules Standard Committee. I'm forgetting the name of it, but it was chaired by a DCA judge who gave that report to the Supreme Court about this particular issue. And one of the things that was discussed and there was questions about by the Florida Supreme Court was about the constitutionality of this. And one of the concerns was hearsay, as you brought up, Mr. Klein's. And I remember, I believe particularly it was, as Justice Curiel had stated, well, confrontation rights are trial rights, and this is not a trial situation. And so I say that to explain that although the argument is made this is not a constitutional issue, the Supreme Court of the state of Florida has at least had this issue in front of them and has not taken up that concern as to whether or not this is constitutional or not. I believe if they thought it was unconstitutional, they would have done something and not changed the rule to allow hearsay in the way that it is allowed with Rule 3.132. So I bring that up to say that this has been looked at by the highest court of the state. Given that, the rule allows for it, the statute allows for hearsay. It says that the rules of evidence don't apply to this particular type of hearing. There are other types of hearings that is the truth, but that's the law. That's the law that's been made by the legislature, and then the Supreme Court promulgates the rules as to how that's supposed to actually work in a court. During these types of cases and these types of hearings, I think this court is not going to do anything differently at this point on those particular issues, but obviously if it goes up through the normal course of appeal, through the District Court of Appeal and ultimately the Supreme Court, there may be a difference at some point. I don't know, but I'm kind of giving you that as the basis as to why a constitutional challenge to this particular issue won't be basically granted at this point. As far as the evidence that's been submitted, it seems clear from the testimony of the officer and the records of the investigation, which include several eyewitness reports to what actually happened. I understand, Mr. Klein's, your argument that there will be a stand your ground motion filed at some point, but that there's no evidence other than what's in front of me. So the evidence is that the alleged victim in the case put his hands up and said, "Whoa," at which point, according to the reports and witness statements, Mr. Brake fired the tan Glock, I think it said a 19 in the report. Several times, there seems to be some discrepancies between the reports as to how many exactly times it was fired. I did find it strange that it said anywhere from 3 to 6 times, yet there was 7 wounds, or he was shot 7 times. I don't know if that was counting entry wounds and exit wounds. I didn't take it as that way because they said he'd been shot 7 times, and there's clear discussion in the reports that talk about what was an entry wound and what was an exit. But shot repeatedly from close range, and leading to the charges for which he's here today, under 907-041, paragraph 5. A3 is aggravated battery, lists that as a dangerous crime, and then 5A9 is homicide. Obviously, this is not a homicide case, but it is an attempted homicide. So under 5A9, 22, the attempt or conspiracy to commit any such crime. So that's why the attempted murder counts under the dangerous crime section of 907.041. I believe the motion filed by the state talks about under both 5C5 as well as 5D that the court should find that he should be held without bond. I'll just quickly go through what those say. 5C says, upon motion by the state attorney, the court may order pretrial detention if it finds a substantial probability based on a defendant's past and present patterns of behavior, the criteria for the statute 903-046, and any other relevant facts that any of the following circumstances exist. Going down to 5, it states, the defendant poses the threat of harm to the community. The court may so conclude if it finds that the defendant is presently charged with a dangerous crime. He is both attempted murder or attempted homicide as well as aggravated battery with a firearm. There's a substantial probability that the defendant committed such crime. I believe based on the evidence that's clear from the reports and the testimony of the one witness, that there's a substantial probability that Mr. Brake is the one who shot the firearm that injured Mr. Wooten. The factual circumstances of the crime indicate a disregard for the safety of the community. I believe pulling the trigger in such a neighborhood in and of itself could be considered a disregard for the safety of the community, but specifically pointing a green laser dot at someone's chest before pulling the trigger would clearly show a disregard for the safety of at least one of those people in that community. And there are no conditions of release reasonably sufficient to protect the community from the risk of physical harm to persons. I'll address that again in a minute. And then paragraph D states if a defendant is arrested for a dangerous crime as a capital felony, life felony, or felony of the first degree, which the attempted homicide case is, and the court determines there is a probable cause to believe the defendant committed the offense, the state attorney or the court on its own motion shall motion for pretrial detention. Again, so even though there's been a motion filed, the court would have had to set this for a pretrial detention hearing anyway. If the court finds a substantial probability the defendant committed the offense and based on the defendant's past and present patterns of behavior, we'll bring up that's not the patterns of what was talked about as far as the allegations in this case, but also a prior record that includes possessing a firearm illegally, consideration of the criteria of 903-046, and other relevant facts, that no conditions of release or bail will reasonably protect the community from risk of physical harm, ensure the presence of the defendant at trial, or assure the integrity of the judicial process, the court must order pretrial detention. So if the court makes those findings, then I have to order pretrial detention. Again, I've already found that there's a substantial probability that Mr. Brake is the one who committed this offense, that it was committed, and he's the one that committed it. I believe there is a pattern of behavior, of criminal or delinquent behavior, as well as those involving firearms. I have considered your arguments regarding the criteria of 903-046, any other relevant facts. I don't believe there's any conditions of release or bail that would reasonably protect the community from risk of physical harm, given the evidence that I've heard here today that Mr. Brake fired a firearm potentially at least 7 times at another individual. As far as the presence of the defendant at trial, I understand, Mr. Klein's, your argument that he could have just been going back to where he's from. I'm not necessarily finding him a flight risk because he went to Bay County at the time that this happened. Maybe that will flesh itself out at some other point. But I do have some concerns about the integrity of the judicial process. That being, everyone has a right to remain silent and not tell law enforcement anything. However, when someone goes out of their way to lie to law enforcement about the presence of the gun, where it is, where it may have been thrown out on the road, I've got concerns about whether or not the integrity of the judicial process will be protected if the defendant is released from incarcerative custody while his case is pending. So therefore, I only have to find one of those 3. I find 2 out of those 3, and therefore the court is going to and must order pretrial detention. Any other arguments or concerns?
No, Your Honor, I was just going to say, the state has already filed the information in this case. We have already filed a written not guilty plea. This case looks like it's already on the April 27th docket. I would just propose leaving it on there for status, obviously.
I think it should be probably April 29th then.
Correct. But leave it on for the late April court date. That way we can update the court on the progress we made toward getting this case ready for
April 29th at 9 o'clock for his pretrial conference.
No objection, Your Honor. I would just ask that the court, in addition to holding him on zero bond, issue a no contact order for Dustin Wooten.
Well, I apologize for that. I didn't go through the rest of the other charges for which he's currently facing and other conditions. Conditions of his bond, even, and just Mr. Briggs, so you understand, even if you're not released, these conditions still apply. So no contact with the alleged victim in the case, no contact with any witnesses, and except through your lawyer through the normal discovery process. That includes the 2 children who were allegedly present during that particular time. Don't return back to the house at 264 Swain Pine Court. And you're in Crestview. You're not to own or possess any firearms if you're to be ever released during the course of this case. Was there something else I missed, Ms. Bliss?
Judge, there were direct issue charges in the information. Do those need to have bonds assigned to those charges?
I will address all of the bond amounts.
Okay.
So for the 2 counts of child neglect, it'll be $5,000 cash or professional each. For the discharging a firearm in public, it'll be $10,000 cash or professional. Grand theft of a firearm will be $5,000 cash or professional. The 2 petty thefts will each be $1,000 cash or professional, and the possession of a firearm by a convicted delinquent under the age of 24 will be a $25,000 cash or professional bond. Anything else that I may have missed?
Nothing from the state, Your Honor.
Nothing from me, Your Honor. I'm just trying to explain this to.
Okay, and I'm giving all exhibits to the clerk for filing.
And I believe defense counsel's filed a waiver of arraignment.
I believe so. Written plea of not guilty was filed on February 2nd.
Okay.
No, this is a transport list. I believe that's all I have today, if I may be excused, Your Honor.
All right, thank you, Mr. Kleins. You don't have anything else on the afternoon
I'm gonna
dockets?
stick around to watch the hearing with Mr. Terrell, because I have him on county board stuff, so that's the only reason I'm gonna be here.
Maybe
Thank you.
excuse Your Honor.
Yes, and everyone else can assume their positions at the desks. Oh, let me ask really quickly. Is Christopher Estrada here? Come on up, sir. I think, Ms. Flowers, that's the case that y'all are dismissing.
Yes, Judge.
It's going to be quick, Mr. Estrada. To the podium. All right, Mr. Estrada, your case was brought up briefly this morning. It's my understanding the state is dismissing the violation of probation.
Correct.
All right, so your case is dismissed. Is he still on probation, or is that expired, or going to expire?
It was set to expire in February, I think it was February 26th. So
Let me double check.
it would be the state's intention if, I'm not exactly sure how probation handles this. I think probably the violation was filed because it was coming towards the end. So we could dismiss the VOP and terminate probation.
Okay.
There's nothing left for him to complete.
Probation have any further input than that? I believe the issue was, it was an issue about an impound on a DUI charge. Mr. Estrada doesn't have a vehicle to impound. It's the only thing that he had left. The department had issued a request for a violation of probation due to the fact it hadn't been done. I issued you a notice to appear because I didn't want you to be arrested for something that you couldn't change. So that's why you're here and standing in the place you are and the way you are. So I didn't want you arrested for that particular issue until I found out exactly what the facts are that I just found out, because I assumed it to be the case, but I didn't want to make a decision based on that. Probation have anything else?
You just need to check in with his office when you leave here.
I understand the term date was within the next couple of weeks, correct, Mr. Estrada?
Yes, Your Honor, and I appreciate it.
Okay, what I'm going to do at this point is the VOP has been dismissed. You have to report to your probation officer. There hasn't been a request for early termination, and since technically you didn't finish something you were supposed to do, but I don't think you can, I can't early terminate you at this point without a previous motion, but just check in and you're set to expire the next couple of weeks or so.
Thank you, Your Honor.
All right, thank you. I just didn't want you to sit for the rest of the afternoon and get called later because
you
they
so
had told
much.
me about it earlier.
I'm just nervous.
All right, no problems. Thank you, Mr. Estrada. You're free to go. Thank you, Steve. Yes. All right, we're going to begin our 1:30 docket, which is our arraignment docket. What I'm going to do is announce each person alphabetically. When I call your name, come up to the same lectern that you just saw Mr. Estrada at. I'm going to make sure that, number one, you know what you're charged with, tell you your case number. If you have a lawyer, that lawyer will be standing next to you to discuss your case with you. If you don't have a lawyer, I'm going to ask you if you're going to hire one or if you want one appointed, and then we'll set you for your next court date. First case is going to be Frank Collins, and followed by Thomas Craig. Sir? Well, I mean, that's part of this one. Mr. Maddox, I think this
Yes, Your
one is yours.
Frank Collins, yes, Your Honor, he is.
Mr. Craig, just hold on. I just called you so you're ready to go next, but you can stand there at the rail. All right, this is Frank Collins, 26 CF 69. So an information been filed.
Yes, Your Honor, and information's been filed, went to a plea of not guilty at this time.
Okay. All right, plea of not guilty has been entered. Are you going to want April dates or?
Yes, Your Honor, April dates, please.
Okay. All right, your pretrial conference date, Mr. Collins, is going to be April 29th at 9 a.m. So we'll see you back on that date. Obviously, Mr. Maddox will talk to you in the meantime, I'm sure, about any other motions or things that need to be done.
Yes, sir.
All right, Mr. Craig? All right, this is Thomas Ray Craig, 26 CF 75. Has an information been filed? Okay, and I've got it as possession of a controlled substance without a prescription, third-degree felony, as well as possession of drug paraphernalia, a first-degree misdemeanor. Mr. Craig, do you understand those charges? And can you afford a lawyer to represent you in this case? I need to hear you out loud, Mr. Craig. Okay, just speak into the microphone. It'll.
Motion. No, sir.
You're very soft-spoken, Mr. Craig. It's just, I'm getting the gist of it. I just want to make sure that our audio record is picking it up. All right, I'm going to go ahead and appoint the public defender for you, Mr. Craig, but you're going to have to take one of those applications that's on the lectern there in front of you. It's a financial affidavit form. You're going to have to fill that out, bring it down to the first floor clerk's office before you leave here today. Is the form there?
That's the one he's talking.
The PD application? All right, and then, Mr. Craig, your next court date's going to be April 27th at 1 o'clock. Make sure you stay in touch with Mr. Maddox, and we'll see you back on that date.
Thanks, sir.
All right, next is Javaris Durham.
Yes, Your Honor.
Oh, plea of not guilty will be entered on his behalf. All right, you got any information you handed him? All right, Javaris Durham, 26 CF 53, charged with drive-while license, suspended, third-degree felony.
Yes, Your Honor, we have a time-served offer in this case. My client intends to take it, just needs the state signature.
I think I just signed it, let me just double check.
Same thing we talked about. Plea. date it for you. May I approach, Your Honor?
Yes. All right, Mr. Durham, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir. Yes, sir.
All right, can you state your full name and date of birth, please?
Javaris Milton Durham, 9/30/1998.
All right, Mr. Durham, you're here, as I said, in 26 CF 5-3, charged with drive while license suspended as a felony, third degree, punishable by up to 5 years. Do you understand that?
Yes, sir.
I've been handed a plea and sentencing agreement between you and the state attorney's office that calls for you to plead no contest to that charge. You'll get credit for time served, adjudication of guilt, $615 in court costs, $150 cost of defense. I'll give you 90 days to go ahead and pay those costs or set up a payment plan. Is that the agreement that you've made?
Yes, sir.
Is that the state's agreement?
Yes, Judge.
All right, Mr. Durham, have you gone over this plea and sentencing agreement with your lawyer?
Yes, sir.
And did you understand and sign it?
Yes, sir.
Did you need any more time to talk to him about it?
No, sir.
Are you satisfied with his advice and representation?
100%.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
All right. And has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement I just read?
No, sir.
And or do you understand that by entering a plea that there won't be a trial of any kind?
Yeah, yes, sir.
All right, and you're giving up your trial rights, which are on page 2 of that agreement that you've signed.
Yes, sir.
Do you understand you're waiving all potential defenses you may have?
Yes, sir.
And do you understand if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
And what is your plea to the driving while license suspended third-degree felony?
No contest.
All right, I'll accept your no contest plea as freely, voluntarily, knowingly given. Adjudicate you guilty, credit for time served, $615 court costs, $150 cost of defense, 90 days to pay that, or set up a payment plan with the clerk's office. I do need you to be fingerprinted because it being a driving while license suspended, and you'll have 30 days to appeal the judgment and sentence of the court, Mr. Durham. This is a guideline sentence as he scored 25.70 points. All right, head straight up here, Mr. Durham. Thank you very much. All right, Brandon Eastlick.
Yes, Your Honor, we'll have a resolution in this one. Just need to finalize that with Mr. Sprouse. So I talked to him about it, though. Okay, I'm just finalizing your plea. I'm going to pass you for a few minutes, get you back out here, okay?
Okay, yes, sir.
Hold on.
All right. You're going to bring him back up?
Yes, Your Honor.
All right.
I'll have it ready in just a few minutes.
All right. Steve, he's going to go back when we need him back.
It's going to be a plea to a lesser included, Your Honor, 6 months probation.
All right. Is it Zytravian Flagler? Are you Mr. Flagler? Yes? Okay. Mr. Flagler, you're here in 26 CF 87. It's a charge of grand theft. You understand that charge?
Yes, sir.
You don't have an attorney, is that right?
Yes, sir.
Can you afford one?
No, sir.
All right, I'm going to appoint the public defender to you, Mr. Flagler. You will have to fill out one of those applications that's to your right on the podium there. Fill that out today, go turn it into the clerk's office before you leave. It's downstairs on the first floor. All right, as far as your case, a plea of not guilty, Mr. Maddox?
Yes, Your Honor, plea of not
Plea of not
guilty.
guilties are being entered, and then I'm going to give you April 29th as your next court date. That's going to be, I'm sorry, April 27th at 1 o'clock. All right.
27th and the 29th for the next one.
Yes, and I made the mistake there. So April 27th at 1 p.m., stay in touch with Mr. Maddox, and we'll see you back on that day. All right. That Jabari fountain. All right, Mr. Maddox, I got you on Mr. Fountain as well. He's here in 26 CF 28, charged with battery by a detained person.
Yes, Your Honor. In this case, we just had him set to see if the state filed an information. The state has filed an information, although I would point out, Your Honor, there's no victim listed in that information. Or at least not the one I saw, perhaps. I didn't miss anything.
Did unlawfully commit a battery upon blank space, comma.
Okay.
Who at the time was a visitor or other detainee in the defense.
So, deficient information, but one has been filed.
Okay. All right. And you're entering a,
I guess I'll enter a plea of not guilty, I suppose.
okay, well, you can certainly file any other motions.
No, I
Mr.
know, it'll
Maddox.
get fixed, Your Honor. I'm
All
sure.
right. Mr. Fountain, your next court date's going to be April 29th at 9 o'clock for pretrial conference. Does he have any other cases in this division?
Not in this division, Your Honor. He has 2 in the south end. The issue of whether we were going to transfer him came up, but my understanding is the state intends to keep this case here.
Okay. All right. Dominic Isaac.
Judge, it passed for last time. The state hadn't filed an information yet. Come over here, Mr. Isaac. But we've got a negotiated plea. Counts 1 and 3 are misdemeanors. It'll be 11 months, 29 days probation. Count 2 will be 2 years probation. And the terms are set out in the plea offer. They'll all run concurrent.
All right, Mr. Isaac, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, can you state your full name and date of birth, please?
Parker Johnson Isaac.
Can you pull that microphone over to him a little bit?
Dominique Parker Johnson Isaac. Date of birth is 12/12/95.
All right, Mr. Isaac, you're here, as I said, in 25 CF 2476, charged with misdemeanor battery, domestic violence, which is punishable by up to a year in county jail, possession of a controlled substance, third-degree felony, punished by up to 5 years in state prison, and possession of paraphernalia, also first-degree misdemeanor. Do you understand those charges?
Yes, sir.
All right, I've been handed a plea and sentencing agreement between you and the state that calls for you to plead no contest as charged to each of those 3 cases, or I'm sorry, each of those 3 counts. In return, it would be a withhold of adjudication on the misdemeanors, 11 months, 29 days probation. On the felony count 2, it's 2 years of probation. The conditions of your probation would be batter's intervention, which is a 26-week program, no violent contact with the victim in the case, substance abuse evaluation, any recommended treatment, no drugs or controlled substances without a valid prescription, take all mental health medications as prescribed, and then your court costs would be DV battery, so what is that? I missed it. 622 in court costs. Oh, I'm sorry, you've got 870 here.
I thought an old form that I had 870. Clerk says it's 622. We'll certainly take it lower.
There's a drug charge too. 870, okay. It's usually 515, it all depends on what else there is as far as
I went over the
surcharges
add-on.
because of drug cases and domestic violence cases. So it's 870 court costs, $150 PD fee. You'll pay those during the course of your probation. Mr. Isaac, is that the agreement you've made with the state?
Yes, sir.
And is that what you want to do today?
Yes, sir.
Is that the state's agreement? Yes, sir. All right, and Mr. Isaac, have you gone over this form with your lawyer?
Yes, sir.
Did you need any more time to do so?
No, I just had a question.
Okay, what was your question?
If
For me or for your lawyer?
No, for either or.
Okay. I just want to make sure you're not asking me something that is supposed to be confidential to your lawyer, but go ahead.
No, I just wanted to know what the stipulations were about me going back to the residence in which this occurred.
Okay.
Or,
Do I-
with regard to this, Judge, I'm not aware of any injunction case.
Have y'all agreed to anything on that?
Was there, did we not address contact?
No, it says no violent contact.
Well, then, that's what,
All right.
Okay.
So but I would still make sure that you're wanted there before just showing up,
Yes,
Mr.
sir.
Isaac. All right. Did you need any more time now to speak to your lawyer?
No, sir.
Okay, just wanted to make sure. So did you understand and sign the agreement?
Yes, sir.
And are you satisfied with your lawyer's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement that I've announced?
No, sir.
And do you understand if you plead no contest as indicated on the form that there won't be a trial of any kind? And do you understand you're giving up your trial rights, which are on page 2 of the agreement you signed?
Yes, sir.
You understand you're waiving all potential defenses?
Yes, sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion?
Yes, sir.
All right, and what is your plea to the 3 counts of battery, possession of a controlled substance, and possession of paraphernalia?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given. In the 2 misdemeanors, it's going to be a withhold on all 3 counts. On the misdemeanors, 11 months, 29 days of probation. On count 2, the felony is going to be 2 years of probation. That's all to run concurrent, correct? Okay. Batterers intervention program, no violent contact with the victim in count 1. Substance abuse evaluation, any recommended treatment. No drugs or controlled substances without a prescription. Take all mental health medications as prescribed. $870 court costs, $150 public defender fees. This is a guideline sentence. Although the score sheet is wrong. Got possession of a controlled substance as being a misdemeanor. What is the level on a 3rd-degree felony?
Level 3.
It's 3-3? Okay, so that should be 16 points. So it's a total of 16.4 points. So he doesn't score. All right. Mr. Isaac, I need you to speak with probation before you leave. I also need your fingerprints, and then you have 30 days to appeal the judgment and sentence of the court.
Judge. Judge, that's all the business I have before the court today, if I can be excused.
Please, thank you. All right, Jalen Parker. All right, Mr. Parker, you're here in 26 CF 56, where you're charged with reckless driving, 2nd-degree misdemeanor, driving without a valid driver's license, 2nd-degree misdemeanor. No motorcycle authorization on your driver's license, 2nd-degree misdemeanor. Possession of a controlled substance, that being less than 20 grams of cannabis, is also a 1st-degree misdemeanor. And then counterfeit license plate or validation stickers, which is a, one second, did I miss one? I missed the resisting, is also a misdemeanor. And then count 6 is counterfeiting license plate, which is a 3rd-degree felony. Do you understand what you're charged with?
Yes, sir.
Okay, you don't have an attorney here. Are you going to hire one, or do you want me to appoint you a public defender?
Appoint me one.
All right, can you afford a lawyer otherwise?
No, sir.
Okay, I need you to fill out one of those forms that's on your right there. Bring that down to the 1st floor clerk's office and turn it in before you leave. This is Landon Maddox with the public defender's office who will be representing you.
It'll be Miss Rivers, Your Honor, but I do want to at least give him a.
Okay, so Ms. Rivers will be the one that's representing you. She's just not here today. So make sure you get in touch with Ms. Rivers, and then we'll see you back on April 27th at 1 o'clock will be your next court date.
All right. Thank you.
Thank you. All right, Haley Pennington. She's incarcerated. Yes. Oh, hold on a second. Pennington? Oh, I'm sorry. I thought you said there was a plea not guilty. Yes, plea of not guilty on behalf of
Yes, yes, Your Honor.
Mr. Parker. I thought you were saying there was a plea of not guilty on Ms. Pennington. All right, Ms. Pennington's here in 25 CF 2446. Possession of a controlled substance without prescription, possession of paraphernalia, and DUI. Mr.
Yes, Your
Maddox?
Honor. We'll enter a plea of not guilty at this time.
All right, it's going to be April 29th at 9 o'clock for your pretrial conference date, Ms. Pennington. Ms. Rivers will be representing you, is that right?
Have an offer in the case?
Not at this time. I have to evaluate the.
Okay, well, there's no offer. Yes.
Yeah.
Yeah, there's no offer.
All right, April 29th, the plea of not guilty being entered, Mr. Maddox?
Yes, Your Honor.
All right, April 29th at 9 o'clock.
Mr. Rivers will be able to see you, okay?
Thank you.
All right, and next is Joshua Ramsey. I don't have Ramsey. Oh, he was listed on the morning's docket as well.
Oh, okay. Hey, sir, how you doing? Doing all right? Information.
All right, this is 26 CF 77. Mr. Ramsey is charged with possession of controlled substance, third-degree felony, possession of less than 20 grams cannabis, first-degree misdemeanor, leaving the scene of a crash involving property damage, second-degree misdemeanor, DUI, do-ball, and damage to property is a first-degree misdemeanor. Refusal to submit to testing is a first-degree misdemeanor, second-degree misdemeanor. And finally, possession of drug paraphernalia, first-degree misdemeanor. Do you understand all those charges, Mr. Ramsey? All right.
Your Honor, we'll enter a plea of not guilty.
All right. April 29th at 9 o'clock for pretrial conference. All right. Brian Rogers. Rush will be next. All right. Are you Mr. Brian Rogers?
Yes.
All right.
Thank you.
26 CF 48. You're here charged with drive while license suspended, third-degree felony. Do you understand that?
Yes, sir.
Can you afford an attorney to represent you in this case?
No.
All right, I'm going to have you fill out one of those forms on the right there. Make sure you bring it downstairs to the first floor clerk's office. Mr. Maddox?
Driving license suspended, that's your only charge?
Yeah.
Does the state have an offer in this case? The driving while license suspended?
Sorry.
Let me look.
If not, it's okay, I'll just continue it. Or plead not guilty, I mean.
I mean, it's gonna take me a minute to look it up, so hang on.
Well, what I'm going to do is enter the plea of not guilty, put him on April 27th at 1 o'clock. If y'all work something out and you want to bring him back up, Mr. Maddox, you certainly can.
Yes, Your Honor. All right, sir.
All right, thank you.
All right, Tyrone Rush.
Let me give you a card.
All right, Mr. Rush, you are here in 25 CF 2475, which is a DUI, fourth or subsequent offense, which is a third-degree felony. Do you understand that? Yes. All right, can you afford an attorney to represent you in this case?
I had a public offender, Ms. Rivers.
Okay. Was she already appointed to your case?
Yes, sir, that's what you're charged with currently. Talk about that, today's not the day to talk about that, sir. Oh, Ms. Rivers will be up to
I
see.
think he was here last week, but there was not an information filed.
Okay, is that the situation, Your Honor? Has an
But
information?
Ms. Rivers was listed, so I'll make sure that the public defender is appointed to your case, Mr. Rush.
Okay.
Your pretrial conference is going to be April 29th. At 9 o'clock.
Yes, Your Honor.
Oh, I don't have
And then we'll enter a plea of not guilty if I didn't already.
Jonathan Smith is next. Thank you, Mr. Rush.
Mr. Rivers will be up to see you, sir. No. You're good.
Mr. Rush? Jonathan Smith? All right. Looks like the public defender's been appointed, Mr. Maddox. It's
Correct, Your Honor.
26 CF 23, aggravated battery with a deadly weapon and criminal mischief, first-degree misdemeanor.
Yes, Your Honor, went to plea of not guilty.
All right, Mr. Smith, it's going to be April 29th at 9 o'clock for your pretrial conference.
Mr. Rivers will be up to see you, sir.
I'm going to try real hard on this one.
Oh, yes, that's a tough one.
Dashovic?
That's pretty good. That might be right. She's out of jail?
Come on up.
Hello, ma'am. Tell us
That
how to
wasn't
pronounce your
anywhere
name.
close, huh? Todosievich.
I don't think I'm gonna be able to do that. I'm gonna stick with ma'am for now.
You too?
Okay. Luckily for you, I won't be your attorney, so hopefully your other attorney will be able to pronounce your name properly. Your Honor, went to a plea of not guilty today.
Let me just, this is 26 CF 52, aggravated assault with a deadly weapon, third-degree felony.
Yes, Your Honor.
All right, it's going to be April 27th at 1 o'clock. Your attorney's going to be Miss Rivers. She'll come, make an appointment to meet with her before that date.
Okay,
You've already
good.
spoken. Okay.
Got the number. Okay, perfect.
All right, thank you.
That's it,
April
ma'am. That's
27th.
it today.
1 o'clock.
Okay.
All right, anyone that we missed on the arraignment docket? I'll check it just to see if maybe there's a plea of not guilty was already done in writing. All right, was there anyone else that was supposed to be on the 1:30 arraignment docket that wasn't called?
I just have Mr. Eastlick to recall.
Okay, we'll call him back once y'all are ready.
Yes.
All right, do I have anything quick? Didn't. Let's see if I have Katie follow up on that.
Mr. Eastlick.
Take another look at it. All right, this is Mr. Eastlick.
It is, Your Honor, recalling case number 26 CF 50. All right. Sign right here for me. Waiving right to any defenses you have. I date it for you, sir.
Are y'all transporting? Thank you. Yeah, you're already here.
Moving slow. Moving slow.
All right. All right, Mr. Eastlick, can you raise your right hand, please, and be sworn? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your full name and date of birth, please?
Brandon Lee Eastlick, 4/20/1993.
You can put your hand down. All right, Mr. Eastlick, you're here in 26 CF 50, where you're currently charged with, was it burglary or attempted burglary?
I believe the information filed by the state was burglary of an occupied dwelling on an F2.
Okay. So it's a second-degree felony, punishable by up to 15 years in state prison, as well as criminal mischief, first-degree misdemeanor, punishable by up to a year in county jail. Do you understand what you're currently charged with, Mr. Eastlick?
Yes, sir.
That's okay. I'm just going to go through what the agreement says now.
Yes, sir.
I've been handed an agreement between you and the state that calls for you to plead to a lesser-included offense of trespass. That's Florida Statute 810.091A, as well as pleading as charged to the criminal mischief. In return, you'd be adjudicated guilty, 6 months of probation, reserved jurisdiction for any restitution to be paid back for a period of 90 days, $270 in court costs, $100 cost of defense, and then waive cost of supervision due to the fact that you've been found to be indigent. Is that the agreement that you've made, Mr. Eastlick?
Yes, sir.
Is that the state's agreement?
That is the state's agreement, and it's done in accordance with Marcy's law. We tried to reach out to the victim. They did not respond.
Okay. All right, Mr. Eastlick, is this what you want to do today?
Yes, sir.
Have you gone over this form with your lawyer?
Yes, sir.
Do you need any more time to do so?
No, sir.
Did you understand and sign the form?
Yes, sir.
Are you satisfied with your lawyer's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir. Not
You
never
current-
again.
Say again?
I said, no, sir, not never again.
Okay, well, okay. Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement that I've read?
No, sir.
You understand by entering a plea of no contest that there won't be a trial of any kind?
Yes, sir.
And you understand you're giving up your trial rights, which are on page 2 of that agreement you've signed?
Yes, sir.
And you understand you're waiving any potential defenses that you may have?
Yes, sir.
And you understand if you're not a U.S. citizen, that this could lead to your deportation or exclusion from the country?
Yes, sir.
And what is your plea to the trespass, first-degree misdemeanor, and criminal mischief, first-degree misdemeanor?
No contest, sir.
I'll accept your no contest plea as freely, voluntarily, knowingly given, adjudicate you guilty on both, 6 months probation to run concurrent, reserve restitution for 90 days as far as jurisdiction on restitution, $270 court costs, $100 cost of defense, and I'll waive cost of supervision. Mr. Eastlick, I need to talk to probation, who's sitting behind you there, and then you have 30 days to appeal the judgment and sentence of the court. Sir?
Yes, sir.
Your Honor, since there was a victim involved, even though they can't get a hold of them, can we have a no contact with victims?
I'll do this. No contact with victim. However, if the victim gives you a signed affidavit that says he wants contact, then he's allowed to have no violent contact with the victim.
That's fair.
Judge, just for the record and to clarify, I've spoken to my client about that, does not change anything in terms of entering the plea.
Okay. Thank you, Mr. Eastlick. All right. Let's start our 2 o'clock docket. That's Christopher Klein with Mr. Dyram. I believe we're here for a sentencing. Mr. Klein. I think I'm just going to, well, I think I'm going to do the pro se. I should have probably done that first. Say again? No, criminal mischief and trespass, I don't think I need them. They're both misdemeanors and they're not enhanceable. All right, Mr. Dyram, we're waiting on Mr. Klein. All right, 22 CF 1153, we're here for sentencing after the VOP hearing that we had last week, correct?
Correct, Your Honor.
All right, what would you like to present, Mr. Dyram?
Your Honor, I just have argument. Mr. Klein has prepared a statement, if he can read that to the court.
Yes, sir.
I already submitted it to him.
Mr. Klein, can you, if you're going to speak, if you can raise your right hand, do you swear or affirm any testimony you give here today will be the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
Okay.
Is it cool to start?
Go ahead.
All right, good afternoon, Your Honor. I've prepared this letter as my testimony in hopes of some leniency and mercy on the court with your decision today. I have done almost everything required of my probation stipulations. My family, friends, and loved ones have all come together to pay my court costs. We even donated the community service fees to a local charity, which is Manna Church in Niceville, and that happens to be the same church that the chaplain in here in jail is from. And I've been attending the service for a little over 5 months now. The only thing left is my mental health evaluation, and that's something that I couldn't do from in jail. I've asked the mental health rep several times. However, I feel like at this point I don't need it. I've been in the kitchen as a volunteer in Stripes for 6 months now and haven't been in trouble once. I'm actually the kettle cook for dinner shift and feed over 700 inmates daily and have been in this leadership position in jail for over 4 months now. I did violate the terms of my probation, and I hold myself accountable for it. I had no idea that I still owed Florida anything after being transferred to Georgia, and it's my fault for figuring that when I was transferred that my terms were as well. I reported to Muskogee County Probate upon my arrival to Columbus, Georgia, and was informed by my officer that I did not owe anything or have any special terms. I reported every month up until August 24. My ignorance to the law led me to believe that I was free and clear from Okaloosa County. So it is my fault, and I sincerely apologize. I'm hoping that you'll give me another chance at my freedom. I'm actually begging you and the court to show me some mercy. I've lost my apartment in Georgia, my car, and everything. Honestly, though, none of that means anything to me compared to just being with my kids, starting my new life and getting my life back on track. I have 3 autistic children and one that's getting ready for college that need their father. Your Honor, please don't send me away for any longer than I've already been in here. I've already been reformed and rehabilitated. I'm asking for mercy and hoping that the fact that I've paid my fines and done what you've asked as far as donating my community service fees helps with your decision today. Whatever happens is God's will, and I accept it just as I've truly accepted Jesus in my heart. I just want another chance to not miss another one of my children's birthdays again. Thank you for listening, Your Honor, and I pray that you consider everything.
Good.
That's it.
Any other evidence from the defense?
No, Your Honor.
Anything evidence-wise from the state?
No, Judge.
Okay. Sentencing argument, Mr. Sprouse?
Judge, the defendant, while he was on probation before he was incarcerated for this violation, did nothing on probation. The state would ask you to impose the agreement signed by the defendant for the 3 years suspended sentence. Thank you.
All right, Mr. Dyer.
Thank you, Judge. Mr. Klein is 36 years old, Judge. He is self-employed as a concrete worker. He was living in Georgia with his wife and kids at the time. I believe he has a total of 4 kids. They are special needs and require a lot of treatment and help. I filed a letter from the mother of 1 child.
I've reviewed that.
Thank you, Judge. I think she kind of tells how supportive he is financially, physically. I think it's important for the court to know the underlying facts that he was placed on probation for. Mr. Klein was informed about some sexual abuse that may have occurred with his youngest child, and he addressed that with that person, and that's what led to him being placed on probation. These violations are technical. Like Mr. Klein said, the court costs are paid. His community service is paid as well. The mental health evaluation is the only thing outstanding. He turned himself in last year in June. Since then, his family has moved back to Florida. They live with his in-laws. They're basically unable to survive without him. Judge, we understand there's a 36-month suspended sentence. We're asking the court to revoke and terminate his supervision, give him credit for time served, not impose the 36-month suspended sentence. There is a guideline sentence of, I believe, 18.45 months. So we would ask.
Are there new guidelines? I'm looking at the old ones.
I have guidelines with the violation probation points on there.
Can you let Mr. Mr. Dyer, just make sure that he's
Yes.
okay with that, or if there's any objections to it, and then I'll take a look.
May I approach?
No objections, Your Honor.
All right, so if there is a guideline sentence of 18.45 months, under what criteria are you asking me to depart from that, Mr. Dyer?
Your Honor, I'm not asking you to depart from the 18 months because I do not believe I have a legal basis to do so. I'm asking you not to impose the 36-month suspended sentence. Mine's a legal basis, then
Well,
I will
I'm
defer to the
I'm not going to
court.
make one up for you, Mr. Dyer.
I understand that, and I do not have one, Judge.
There's one thing I want to point out,
Go ahead,
Judge,
Mr. Sprouse.
is that if he is the provider for the family, why did his family have to cough up the money for this?
He was incarcerated over the past 6 months.
All right, I've probably stated this, at least a dozen times since I've taken this division over. Suspended sentences are a very difficult thing to deal with because, if I wasn't the judge who imposed it, or that was part of the agreement of it, I just don't know why it was given and why it wasn't. All it simply really does is limit the upper exposure for someone who takes such a plea. There's nothing that prevents the court from going underneath a suspended sentence. I've reviewed the facts of the case that's underlying here, is what he's charged with and what the facts of it were. I see, Mr. Klein, that you didn't do some very simple things that you could have done on probation, but I'm not sure that's worth 36 months in prison. However, your score sheet leads to 18.45 months. I don't have any reason to downward depart. None have been provided, so I'm not even really making a decision on that. So based on that, I don't have any ability to go underneath the 18.45 months. So at this time, I'm going to adjudicate you guilty, revoke and terminate your probation is unsuccessfully completed, sentence you to 18.45 months in the Department of Corrections with credit for all time served. Any any monetary obligations will be sent to judgment. Anything else?
Thank you, Judge.
Thank you, Your Honor.
All right, thank you, Mr. Klein. We have
Have a good
30
day, Your
days
Honor.
to appeal the judgment and sentence of the court. All right, Mr. Rolandi, you want to come on up?
Your Honor, I believe I don't have anything left on the docket, if I may be excused.
That's fine, thank you. All right, Mr. Rolandi, you're here in 24 CF 137. I did see, as far as what you requested for us to hear today, although I got to the end of it and wasn't quite sure if you wanted to have anything heard today at all. So I went through what you filed on January 12th. It says motion requesting court schedule and conduct Richardson hearing. I've also looked at the notice of hearing and matters to be addressed for today's docket, and I've gone through those. But my question at the end was, there's something in here that talked about, it almost seemed like it's scheduling a hearing as appropriate. Under pending motions filed on page 204 of your notice, it says the defendant may request that the court address or schedule for hearing as appropriate the following motions previously filed and indexed on the court's docket. Then you list 5 motions. I didn't quite understand if you were asking them to be heard today or that you might ask for them to be heard today. They're either going to be heard or not. We're not going to keep going around in circles about this. So
May I
what would you
speak,
like to
Your-
do, Mr. Alandi?
We looked at it as, it would be unrealistic to have 5 motions heard in
Who's
one
we?
day. Just, I use that as etiquette, so I, myself,
Okay.
thought that it was inappropriate to bring 5 motions to the judge in one day. So we said that we'd like to start at the top, and, you know, really, we want the C4. The main thing that we want is the C4, and we would like the due process because it piggybacks. It's so closely related to it.
I'm not sure what that means.
The C4 is the other motion we discussed last time. So the C4 is the reconsideration, but the due process is
Okay.
basically the legality.
Well, let's
the
talk about one at a time.
Yes, sir.
Okay. All right, so the motion for reconsideration of the C4 motion, I've reviewed the motion. I've reviewed the audio and visual of the hearing that you had in front of Judge Stone. There wasn't a transcript provided, so I just went back and listened to it. I'm not sure if y'all have got a copy of that video or got a transcript from it to know exactly what was said, but I have reviewed that. So tell me why you'd like me to reconsider that.
At the time the court made the denial, we later received evidence of a DNA sample from the lab, which is dated June 3rd, 2024. So at the time that this traverse was made by the state, they held factual evidence that the DNA sample was on a scalpel, but yet they were still wielding a dangerous doctrine that we used a house knife. So at the time that she made this traverse, she said that there's speculation of the item used for the circumcision when they held the report for 1 year and 3 months.
Do you have a copy of this report, Ms. Leone?
It's from the Chief of Police, Mr. Robert Bage.
I asked someone else a question, Mr.
I'm sorry,
Alandi.
the DNA report?
Yes.
Yes, I do.
Okay. When was it turned over?
It was, to us, Your Honor, we received it right before turning it over to Mr. Rolandi. We turned it over on 12/5, I believe.
That, very close to what she said, yes.
It was not, Your Honor, in our possession prior to disclosing it to Mr.
Do
Rolandi.
you have a copy of it?
Would the court like to see it?
I would.
Yes, yes, Your Honor.
Either of you know the date that the traverse was filed?
I'll get that one second, Mr. Rolandi.
I have it right here. Thank you.
No, I'm-
Just to help me find it here.
No, I'm gonna just give it to the judge. I wanted to show you what I'm giving the judge. Is that okay?
Yes.
Thank you.
I have it here.
Just so you know, Mr. Orlandi, each side is supposed to make sure that you know what this is before they give it to me, so you don't think they're handing me some note that says something else.
And then,
Your Honor, it was 10/21. 10/21.
yes, Your Honor, that's correct. The traverse was filed on October 21st.
I couldn't find it, and it's listed on here as notice of confidential information with court filing.
That's a filing that Mr. Rolandi did.
No, I just
Oh.
opened it up, and it says states traversed a mirror to
Oh,
defense.
okay.
It's just, that's
Sorry.
why it's so just about impossible to find things that should be readily, readily and easily found. All right, so, Mr. Alani, like I said, I watched the video, I want to say it was Monday or Tuesday of this week. So I reviewed what Judge Stone, what his decision was, and my note is that he denied it due to the state's traverse finding there was a dispute of material fact, specifically the, quote, interpretation of the doctor's notes. So I think the issue is it's the ultimate finding of fact for a jury or a fact finder. I know you've talked about doing a non-jury trial to make those determinations based on hearing the different sides of the evidence. You say that there wasn't permanent injury because of what the actual findings were by the doctor. They disagree with what it says. I know you both talked about what it actually says or doesn't, and I think that's the issue. When you disagree on what the facts are, then that's why it's not a C4 motion. A motion to dismiss in a criminal case is much different than, say, a civil case. Basically, it has to be, say, everyone agrees on what the facts are, and there's only one legal interpretation to be made of that. So it's not to say that anything about the quantity or quality of the evidence, but simply, is there an agreement on what that evidence is? It's clear that you and the state disagree on what those facts are, and that's why Judge Stone denied your motion to dismiss, and I'll not reconsider it any further than that, because that's the standard. So to the extent I've reconsidered it by watching it, because I wasn't a part of the first hearing, I am going to deny your motion to reconsider.
May I respond for the record and procedurally?
Of course, sir.
So Judge Stone said that he was going to review it when we asked for the reconsideration because there was added in language. So what Ms. Barickman said was not even in the report. So it was speculative.
I've seen the report, sir.
But it was so he said that he was going to review it because the doctor doesn't say injury anywhere in his report. But she said that he said injury. We gave you the transcript and the deposition of his doctor note. He didn't even say what she said. So that's not just a misinterpretation. That was added in. He doesn't say that. He said it very carefully. If you go back, he was scripted. He said that anybody with a dorsal slit or a circumcision, that is what he would say is a permanent change, a disfigurement. But when she asked if the boy was hurt in layman's terms, he simply said, I cannot say that.
Okay, here's the issue. And I think based on my review of some of the hearings that y'all have had and some of your pleadings, Mr. Rolandi, the state has filed an amended information of both child abuse and child neglect, both of which without permanent injury, without great bodily harm. So the argument that there's not great bodily harm or permanent disfigurement is not really an issue because they haven't charged you with that.
Well, Your Honor, when it's a religious ritual as dedicated as this, the state should tread very lightly.
Well, that's not the issue, though, Mr. Rolandi.
That's the issue for me, though, Your Honor.
Can I finish? The issue is what a C4, a 3.190 C4 motion does, and the way it's supposed to be interpreted by the court is there an agreement on the facts? There's not. And so therefore, the traverse was accepted, and the motion's been denied. You've asked me to reconsider. I have. I didn't consider it in the first place, but I reviewed exactly what was argued, and I'm denying your motion. I understand that you believe other things as to why this case shouldn't go forward, but that's not what the subject of the C4 motion is.
The defense believes that the court has been able to be projective or objective, as Judge Stone said when he recused himself. So we don't see it as a fair playing ground at all. So we take exception to your ruling. We would like it be documented for the record for the appellate court in case a railroad does take place.
Okay, I'm not sure who you think is railroading you, but everything that happens in this courtroom is recorded, both audio and visual. So,
Your Honor, the state left those charges like that for over a year and a half, and they had that report in their hand. And then they took it off when we put forward our C4 that they agreed to in principle with Glenn and Jason.
I don't know who you're referring to.
I'm referring to the prior counsel.
Well, no agreement was entered. I don't know what to tell you, Mr. Rolandi. I can only deal with the court file as I have it. You've asked me to reconsider something. I have reconsidered it, even though I wasn't the first one to consider it. I've looked at everything. I've denied your motion. What else would you like to have heard today?
We could move forward to the due process.
What is that, or what are you claiming there?
You-
Which motion are you referring to?
Go to it, Your Honor. We've filed quite a bit in this case.
It's index 146, Your Honor.
Okay. And again, I've reviewed them all. I just want to make sure I know which one he's asking for.
Yes, yes.
Is that what you're wanting to go forward on, Mr. Rolandi, number 146?
We would like that one to be heard, and then really where we're going after that is we just want to kind of freeze, reserve, and preserve the rest of the motions just for the record. And at this point, we just think that this is basically, we just get deferrals and judges recuse themselves, and we just round and round we go on this merry-go-round.
I'm not sure what you're referring to. You've had one judge for the entirety of your case until.
I had Judge Brown initially.
Okay, but that was changed because of a division rotation. It wasn't a recusal or a disqualification. All judges in Okaloosa County at the circuit level rotated as of January 1st of 2025. Your case, I think, started in December of.
January in 2024.
Okay, so you had him for a year.
Pretty much.
Okay. And so there was no recusal or disqualification there. It's just a rotation of judges. We do that every 3 years. I was in a family law division. On that same date, I rotated into the criminal and civil division. So the only recusal that you had was Judge Stone, which was from just December of this past year, correct?
Yes, Your Honor.
So I don't plan to recuse myself unless there's something that you bring to my attention. If you file a motion to disqualify under the rule, I'll certainly entertain it as I'm legally required to do. So the speculation as to it's going to happen with a bunch of judges, I'm not sure why you're saying that, but I'll deal with it as they come.
We just, okay, I saw that the nature of the alleged offense is religious. It's deeply religious, the most religious ritual that's enshrined in religion.
Okay.
And so the state should tread lightly, but yet that wasn't really the position that they took. It was kind of like a shoot first, ask questions.
Which motion are we handling right now?
We're doing the due process, so that's the misidentification. The officer shuts
There's
off.
nothing about religion in that motion. That's why I'm just.
It's been hidden from the case. That's why we're bringing it up, because basically the state hid all religious aspects of the offense because, of course they would, because that's a constitutional nightmare. But they didn't have those things, and then they submitted them much later in the process
All right,
of this case.
This is what you're not understanding, Mr. Orlandi. Your motion that you said you want to have heard right now says nothing about religious ceremonies or anything else like that.
No, that was
It talks about incorrect identity, charging you under the name of another individual with a different criminal history that was relied upon, falsified inaccurate information, arresting officers, clerks, prosecution proceeded despite clear discrepancies. And then, so tell me about the wrong identity issue that you're concerned about and what prejudice you face because of it.
So I was arrested as a different man, and I wasn't allowed bond because the man and I have a different record. That man had a record. I don't have a criminal record. I'm a first-time offender.
Okay.
So I was denied bond because of that. And so during the week of being in county jail, that's when Glenn was hired, and Glenn came in and we had a discussion.
You could refer to your counsel by his,
I'm sorry.
by his surname, thank you.
Okay, so Sir Counsel came and I told him kind of
Not
what.
actually, sir, his surname, his last name.
Okay, just.
Mr. Swiatek.
Mr. Swiatek.
Okay.
And we had a conversation. I asked him if he thought I was innocent. I told him that it was religious in nature, and he said, I'm going to do my best to get you out.
Okay.
And I was let out on a signature bond by Judge Brown.
Okay.
But after the state and the clerk of court saw that it was a misidentification, instead of like refiling it and, they didn't do that. And so it remained under this man's false identity, and actually you still have that identity on there now. So it took 4 times to spell the defendant's name correctly, but now it's still 10-10-86, so it's still a different person altogether, which is a gross violation of civil rights, because had I have been there, I would have been able to at least talk about bond and receive bond, but I didn't do that because I was already a different human being in the court's eyes at that time.
So what is your date of birth?
January 25th.
The last amended information I see is from October 21st of 2025. Is that accurate?
Yes, Your Honor. The amended information, Your Honor?
It still says his date of birth is 10/10/86? And it says it's the third amended information.
The
I
records
think
that-
it's the third information, the second amended information is the way it should be titled, but
Your Honor, if I may.
let me let her respond
If,
first, and then you'll get your chance to reply, Mr. Rolandi.
Your Honor, if it's a mistake, that can be easily corrected,
Why hasn't it been?
and I cannot
They're
answer
over
to...
2 years into this case, you don't even have his date of birth right, after having his name wrong for almost 2 years.
Some of the records that I was able to review, like the DCF paperwork and records, showed the 10/10 birth date. There are several records, some showing that date and others showing the other date.
I understand possibly why you got it wrong, but why is it taking so long to fix? And admittedly, I understand that you're newer to this case than even I am.
No,
Because I think you took it over from Ms. Barrickman about a month after I got it from Judge Stone, so.
Your Honor, I can only say that I can amend it as soon as possible. However, what I'm trying to establish here, that I don't believe there is any prejudice to this defendant because he's aware of why he was arrested. He has stated himself that he tried to circumcise his baby at home. Like, there is no error about his identity. It is a clerical mistake. I apologize for not having a...
But it's the third straight information that has such a clerical mistake. The first two had his wrong name, or someone else's wrong name. Because if you go to trial with this, you can't convict him. It's not him. All right, what prejudice did you face because of this, Mr. Rolandi?
Tremendous.
Okay, explain. Legal prejudice.
Well, being a first-time offender, you figured that things I could have been offered programs, different things. I could have been there the next day when my wife was arrested after they knew it was a religious ritual. I could have been there so my kids weren't taken in the middle of the night on a Friday night. And my children were taken, and that was something that we'll address at a different time. We would like to focus on the matter at hand, but it's been a very difficult process, as you can understand. It's been 2 years. Never once did the defendant ever believe that there was criminality to his actions. That's why he has stayed true to his God and true to his faith. So we believe that the damage that was caused by this misidentification, the correct identifiers were given to law enforcement, and that's in the body cam footage.
Let me explain one thing to you, Mr. Rolandi. This appears to be an issue with the probable cause affidavit or arrest report. Listed you as the wrong name. However, the reason you were held after your first appearance initially was not because of your name and your criminal history, but you were charged with what's considered a dangerous crime under Florida Statute 907-041, paragraph 5. Aggravated child abuse, which is what the charge was, is something that gets set for a pretrial detention hearing. So the reason you were held for a week was that reason, not because of your criminal history. Because in fact, I'm looking at the first appearance paperwork. In the place where they would put criminal history, it says no criminal history. That box is not only checked, but circled. And then handwritten, most likely by someone from pretrial services, wrote, "Name, date of birth, and social security number are wrong on arrest report." So it wasn't because of someone else's criminal history or someone else's name that you were held. It's because of what you were charged with, and you were set for a pretrial detention hearing.
Your Honor, we started off as filing 154, so we were the 154th filing of the year. You can, when you go back and look at the paperwork, you can see that a piece of paper is over the original paper.
Okay.
And they literally scribbled out numerics and changed the form, and then they go from the 154th filing to the 137th filing.
What does that change?
Because you can only go the other way. I mean,
What is your prejudice?
So like my wife was.
What is your prejudice?
It's because instead of refiling it, they fraudulently fraud on the court, changed the paperwork even
Not
if.
fraud on the court. I've read it all, Mr. Rolandi. It's not, no one's trying to convince me that you're someone else.
What do you mean? I thought we just established that. That the defendant was misidentified as a different
It
defendant.
has the wrong name. I don't think it,
Date of birth, but-
being wrong doesn't mean it's fraud. Fraud has an intent to deceive.
Okay, so but if the proper identifiers are given, what excuse do you have for not having the proper identifiers? So James Michael Rolandi was given, my wife gave all the proper identifiers.
How has it affected you? You just told me it's because you were kept in jail for a week. I've explained to you that's not the case.
Well, because, okay, we have pictures that we've submitted. The other man had 16, 17 charges on his record. Of course, I mean.
Your first appearance paperwork says no criminal history, and specifically checked it, circled it, and indicated you are not the person as far as what's listed. There's a mistake in your police report. You were not held in jail because of that.
Okay, so if that's factual, then, I mean, that could be proven in trial. We can move forward with that, and.
That's not an issue for trial unless if you want to file something saying that your civil rights were damaged in some way, you can do that.
Okay,
but that's not what this case is.
But after the court and after everybody was alerted, why wasn't this changed when it was alerted to? Because it was alerted to, everybody did it, and then obviously something changed. I mean, the defendant got a $5,000 signature bond a week later.
Was that at a hearing?
That was at the annex by Judge Brown on January 25th.
That was at the pretrial detention hearing.
And the defendant was given a $5,000 signature bond.
Yes. Which happens pretty frequently at pretrial detention hearings. I had 2 pretrial detention hearings where the state didn't go forward on them today, and they were given bonds and they're released. You weren't held because of some other person's name or criminal history. You were held for a pretrial detention hearing because you were charged or there was probable cause found that you committed aggravated child abuse. I'm not saying you did or didn't do anything. I'm just saying that's the procedure. Under Florida Statute 907.041, paragraph 5, if you're charged with a dangerous crime, which child abuse, let alone aggravated child abuse is, the state can file a motion to hold you for pretrial detention, or the court can do it on its own motion. That's what was done. It was then set for a pretrial detention hearing, which is every Thursday. Each division does that at 12:30 in the afternoon. I did mine today before we had the arraignment docket that you sat through a little bit of. You didn't see the pretrial detention hearing because you didn't get here until afterwards, but that's why I do every 12:30 on Thursdays. At that time, bonds are set if the state doesn't seek pretrial detention. That's what happens. There's a pretrial detention order in your case from January 25th of 2024 stating that the state was here, Mr. Switek was here, and the state presented no evidence to support pretrial detention. So that reason is for why the judge then gave you a bond. And then as far as the order setting bond, let me take a look at that. It doesn't really give any indication other than it's a $5,000 signature bond. It doesn't say why you were given a $5,000 signature bond. So the misidentification had nothing to do with your 1 week of time in jail.
Does it have anything to do now, though? I mean, you still have the wrong defendant.
That's for you to prove to me that you've suffered some prejudice and I should dismiss the case because of it.
Well, it's been 2 years, like you said, for them to correct the problem, and we've said it dozens of times, if not many, many times. and it was never changed. Mr. Swiatek had 14 days to challenge the charging sheet, and he files a motion with Mr. Cobb, and they didn't do it. And I told him, Mike, why didn't you?
Well, I understand
Why didn't you
that,
do it?
but what has gone differently? How are you prejudiced by that happening, by them having the wrong date?
It's just unconstitutional. I mean, all the right identifiers
What part of
were
the
given.
Constitution are you referring to, sir?
Due process, the 14th Amendment, I mean,
Okay.
it's, of course, I gave the right identification. There's no reason for the mishap to happen or occur. The proper identification was given to all authorities.
Okay. But you haven't told me what you've suffered because of this.
We can save that part. There's much more to come. but we're-
You filed the motion, you wanted to have it heard today,
Your
so
Honor,
it's
we're
not
trying
going
to be
saved.
procedural. So we want to focus on the procedure. If it gets into evidentiary, the defense wants to hold evidentiary matters for the trial. We don't want, I'm a pro se litigant. I don't want to be saying things about what happened to me here. I'm not a defendant here today. I'm an attorney. So right now, we're focusing on these things, and when we move to trial, which is where we're pushing after this, because we're going to freeze the other motions, then we can go to trial.
Well, just make sure you understand, once you go to trial, any pretrial motions are considered abandoned if you don't have them heard. You can't have a trial and say, I want to go back and hear my pretrial motions now.
We've raised very serious allegations of discovery violations, Brady Giglio violations, withholding of evidence that was very beneficial to the defense. Detective Wilson's comments, even.
Have you filed a Brady or Giglio motion?
We put that there's.
What's the Giglio claim?
So again, the officer shuts off his camera, does not conclude the changing of arms, doesn't identify the defendant in the body cam footage. And so we later received an impeachable offense from the state that this particular arresting officer was caught giving false affidavits. And so that's why we were bringing it to the court's attention that, wait a second, this is a red flag because we're telling you that the defendant was misidentified. And then this man has that red flag on him that he.
Well, let me just ask you though, because you're claiming a Giglio violation. Who's the person who's not being prosecuted to give fair testimony to the state? Because that's what Giglio's about. And that's my concern, Mr. Rolanda. You're using names of things, and I want to make sure I understand what you're asking for, because Giglio is all about, did the state give some sort of a sweetheart deal to testify against you? That's what Giglio is about.
I just know it to be about discovery and withholding and of valuable evidence.
Well, then you're free to pursue Richardson hearings or Brady violations, but you have to file them correctly. And so just throwing out names of Supreme Court cases, if you're not aware of how they apply, is not going to get us to a final resolution to your case.
These are very serious allegations. We
I
brought them
know,
forward.
and filing proper motions is also very serious in this court.
Yes, Your Honor.
So don't throw out names of cases unless you've researched them as an attorney, because that's what you said you are, and knowing what you're talking about.
Well,
Otherwise,
I'm here in the capacity of an attorney. I'm by no means an attorney, but I'm here in the capacity of one, so I'm not here to tell you how I feel and give you a sob story.
Well, I understand
I'm here to
that.
represent myself in criminal law to that degree. So we brought the C4 and we brought forward the due process. Now we're showing you, there is Richardson stuff, there is serious
All
stuff.
right, but I want to focus on one motion at a time. Anything else regarding the due process issue because of the name that was initially erroneous in your initial arrest report?
Well, there's both names. There's my legitimate name.
I understand.
And then there's the other name.
I understand.
And how that name.
What other prejudice did you suffer because of that?
We'll leave that for a later time.
No, we're not. The motion is now, sir.
If that's not enough, then it's just not enough then.
Motion is denied. Okay, what other things do we need to have heard today?
Procedurally, we'd like to proffer for the record that we take exception with your ruling, and
That's
we would
fine.
like it to be preserved for appellate reasons.
Okay.
Thank you. Okay, moving forward.
Anything else today?
We would like to freeze the motions, and we would like you to set a date for bench trial. That's what
Well,
Judge Stone agreed to.
again, I want to explain to you, if we set the case for trial and the case goes to trial, any other pretrial motions that you file will be considered abandoned.
We don't believe that the court will consider them. We've done what we believe that we've needed to do.
Based on what?
Based on prayer and based on going through the process as it is, we've brought forward some real serious allegations, and the state doesn't have any witnesses, they don't have any proof. So what we say is, if this system has become so easy to put an innocent man behind bars because of some loophole, then by all means, I'm prepared to take that leap. Because if somebody's got to suffer for a Jewish ritual covenantal circumcision, then yours truly is going to be me. Because I'm not going to say any guilt of a covenantal. This is deeply covered.
You're now arguing about yourself as the defendant right now, Mr. Rolandi.
The defendant-
Mr. Rolandi, if I could finish a sentence, please. I let you talk. You told me you wouldn't be doing this, and now you're doing it. I'm trying to make sure there's due process by hearing the motions you want to have heard. You can either have them heard, or you can abandon or withdraw them. But once we set the case for trial, I'm not going to keep going back to hear other motions. So do you want to have more motions heard, or do you
No,
want to
sir.
set your case for trial?
We would like to set our case for trial. The Richardson violations can be adjusted in the trial.
No, they cannot.
That's news to me then, but we'll go to trial then.
Now, is there a witness that you think hasn't been provided, or some evidence that hasn't been provided at this point?
The defense doesn't call any witnesses. We don't have to prove any.
Mr. Rolandi, I think you're very confused on some of these issues. No, ma'am.
Wait until you get to that case.
I'll get to every case.
But just, yeah.
But, sir, I'm trying to make sure you understand how the procedure works. Motions are done before trial. As far as if the purposes of a Richardson hearing, for example, if you show to me that the state didn't provide you evidence properly, or even hid evidence from you, whether it's Brady or Richardson, or even a Youngblood issue, those things can come up. But to have a sanction to that has to be heard pre-trial. Now, if we get to trial and they try to provide, or they try to put on evidence or witnesses that weren't disclosed, you could certainly at that point say, well, Judge, they never disclosed these people. And I would say, State, have you disclosed this witness or this evidence? And if they haven't, I can exclude it at that time. But as far as any other remedy, I can't do that in the middle of trial. That's why it has to be done pre-trial. I'm happy to entertain them, Mr. Rolandi, but you have to bring them. So would you like another motion date to have more motions heard?
One last one. Can we do the Richardson hearing?
Right now?
No. I'd like to schedule it and have it be properly labeled.
Okay. And I can't give you, and I know Judge Stone has done this with you a couple of times too, I can't give you any advice on how to bring it. But just make sure that you're doing your research and bringing what you want to bring, because I can only deal with what the sides bring to me. So any case law you want to provide that talks about the issues, you have to do that research yourself and provide it to me. I do some of my own research too, but maybe you'll find something that I don't find myself. So that's what you have to make sure that you're bringing that, and not just saying we didn't get this when we thought we should have. There's got to be typically more. So read the Richardson case and come back with how you want to pursue that. When would y'all like to have that heard? How soon?
We have pretrial the 23rd.
Yes.
My wife has something the 26th, the Nelson hearing. We'd like to see how that goes.
Okay.
Probably, it's at your convenience. At this point in time, I just want to get my matter solved. So that's.
Well, why don't we do this? Let's go to the pretrial conference, and I'm going to see if I can come up with a date that may work for you all that's outside of another docket, because frankly, I know it's going to take some time. And so I don't want to feel like we're rushed, or that you feel like you're rushed either, Mr. Rolandi. So what I'll do is when we get to the pretrial conference, I'll float to y'all some dates through my office to say, how about one of these days I can give you, say, a whole morning That way, we don't feel pressed for time to get done before other cases have to be called. Does that seem fair, Mr. Rolandi?
It does, Your Honor.
Okay. Ms. Leone, any issues with that?
No, Your Honor.
And I can tell you, just because I've had some time in my calendar open up recently, and I need to find some place, something to fill it, and I'd love to have that be your case if we can do that, where we don't have to feel rushed. But I'd like to hear all pending motions if we can at that time. But so once I give you that hearing date, and everyone agrees to it, then I'll need a notice of hearing that says this is what will be heard. And what I'm going to say at this point, Mr. Orlandi, is any motions that are filed and aren't heard that day, and there's no agreement to continue to some yet another date, are going to be considered abandoned if we set the case for trial at that point.
Understood.
I'm not trying to be threatening or sound like I'm not going to hear it. I just want to make sure let's have them all and get to it, because I've seen plenty of cases like yours before, Mr. Orlandi, of someone who's pro se, and sometimes it's just best to get to the merits of the case.
I think so, Your Honor.
But I'll entertain all the procedural issues either side has. I just want to make sure that I'm hearing everything in the proper sequence so I can make those decisions and then go to the next step. But we can't bounce back and forth between trial and pretrial. Understand?
Yes, Your Honor.
All right, and let me just ask you one more thing. I probably should have done this in the beginning of the court date. You're representing yourself. We've had some discussions before as to whether or not you wanted to represent yourself, correct?
Yes, Your Honor.
And I'm sure you have by either Judge Brown or Judge Stone in the past, after Mr. Switek was no longer on your case, right?
Yes, Your Honor.
Do you feel comfortable going forward still on your own without an attorney?
At this point, I do, Your Honor.
And you're well aware of the advantages of having an attorney represent you, someone who's skilled in the law, case law, evidence code, that sort of thing?
We talked last time about the standby or possibly the trial lawyer when we get to that bar.
Well, just understand that and I'll entertain anything that you ask, Mr. Rolandi. However, if we get to a point of trial, then you ask for a lawyer right before the trial starts, it's probably going to lead to a continuance of the trial. And I only say that because I know you want a resolution to this case. So that's why we had that other hearing where I said, well, let's try to make sure as to what you want. But if you change your mind, I'll entertain those things. But I just want to make sure you understand changing your mind later in the game just causes things to take longer. Understand?
Yes, Your Honor.
Okay. Do you understand the disabilities of representing yourself and that you're not classically trained on the law?
I do, Your Honor.
Okay. And knowing that, do you still want to go forward representing yourself?
At this point, I do, Your Honor.
Okay. If you change your mind on that, I'm going to ask you these questions a little bit pretty much every time we come to court on anything what we call a critical stage of your case. And if you change your mind, just make sure to tell me.
Yes, sir.
All right. Anything else for today?
No, sir.
No, Your Honor.
All right. I'll try to figure out those dates, and when we come back on February 23rd, right? Your pretrial?
Pretrial, yeah.
At 9 o'clock?
Yes, sir.
I'm okay if you show up a little later than that, Mr. Orlandi, because there's going to be a lot of lawyers there that day, too. But if you come in that date, well, I'll give you the dates as possible, other dates for motions. I may even have my assistant reach out to you and Ms. Leone to see and kind of float some of those dates to see if we can get it figured out before we get to February 23rd.
I don't mind watching you back there.
I understand, but I know one of the issues you were concerned with your case being sent to me after Judge Stone recused himself in the South End was the travel to Crestview. I don't want you to have to rush up here just to sit for a couple hours. So I'm giving you that opportunity if you need it.
You could always dismiss case then.
If someone gives me a legal reason to do so, I would certainly consider it, Mr. Rolandi.
I hope we will.
All right, well, we'll see. All right, we'll see you back on February 23rd. Thank you, sir. Have a good day.
You too, sir.
Who's we? Oh, you're stealing his. Thank you.
I'm sorry, may I retrieve the DNA?
Yes, please.
Because it wasn't entered as
I just really wanted to see what the dates of it were.
Thank you.
All right, I'm just going to go alphabetically. Donald Robinson with Mr. Gilbert.
Can we approach, Judge?
Approach?
Yes.
Okay.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out Amanda's
All right, this is 24 CF 2138, State of Florida versus Donald Ray Robinson. Oh, there he is. We're here for a motion to suppress. Is everyone ready to go forward?
State's ready.
Yes, Your Honor.
How would you like to proceed, Mr. Sprouse?
I am going to play a video that the defense and state has stipulated to its authenticity. Am I correct in that assertion?
Mr. Gilbert? Okay. Is everything on the one disc, Mr. Sprouse?
Yes, Judge.
Okay. So based on stipulation, the disc is going to be admitted as States 1.
Yes. And I guess I'll do if I could do a brief opening statement while I'm getting this ready.
Okay, go ahead. If you can do those two things at the same time, that's great.
I'm going to give it a try. Judge, we're here on defendant's motion to suppress. The issue is really what constitutes a unreasonable delay in a traffic stop. The state's position is that the delay for a canine search, that delay would have to come like after the traffic stop concluded, and that would be unconstitutional, as the Rodriguez case states. However, in this case, the traffic stop was not concluded before the dog walk occurred. That video will show the facts that Canine Officer Gonzalez arrived on scene before the ticket was completed. Canine Gonzalez asked for security per OCSO policy while there's a dog walk. And then the alert came within seconds of the beginning of the dog walk. Therefore, not a violation.
You ready to present your evidence?
I don't think I have
How long are the videos?
It'd be 8 minutes.
Okay. Do you want to take a seat back there with your client at the desk, Mr. Gilbert, or you're free to stand there as well?
I'm not able to publish through the court system, but
Why not?
because my connections are for the CD, and I don't have a connection for the system.
You-
I can play it.
I
You
think
want
she-
me to play
I
it
think-
with my computer?
Because I don't have
The
HDMI.
HDMI, I do. I do. Get the disc? Oh, do what you need to do.
May I have the screen, Judge?
Yes. I just typically don't put it up until you're ready to go, otherwise people would see everything on your computer.
Charlie Papa 7 Quebec Lima, CP 7 QL. It's gonna be a silver Chrysler 300. It'll be at North Lincoln Beach.
How you doing? You were going too fast on Lloyd Street there. I was behind you doing 40. It's 25 on Lloyd. You got your license, registration, proof of insurance?
I don't appreciate it, so it's my friend's home.
Okay.
Say that was wrong.
She said,
You didn't say that was wrong.
huh?
You didn't say that was wrong.
Okay.
It said 30 mile an hour. It's 25.
Correct.
It's 30. It's like 29, 36.
I got you. You got your proof of registration for the vehicle?
Not my fault.
Okay. You still live on Foxhound?
No, sir. I just moved. I live right here.
What's your current address?
296 Oakdale.
296 Oakdale?
Yeah, apartment 212.
Apartment 212?
Yes, sir.
What's the current phone number for you?
850. 612 6200.
612
6200.
620.
6200.
You don't have nothing illegal in the vehicle? No firearms? Illegal substances? Nothing? Okay. Alright, give me just a second, alright?
5 unit check.
Temple, copy of floor 27, please. Romeo 152-196-74-1780. 1048. I'm gonna need 185. Hey, the zip code over there, is that 36 or 39? You don't know? Okay. Huh? Okay. Go ahead.
He's showing current balance, cost B expiration 5/18/32. He is for inmate release status. Got a local jacket. He's going to be flagged for extra criminal, convicted felon, address suspect probation.
Tell him. Black male, white t-shirt, black pants, pulled up in a black Chevy Camaro convertible. I haven't given him your spiel. If you want to go ahead and use your part. 5-4. I have not given him your spiel yet, so if you want to go ahead and.
you doing, bud? You doing all right? Good. So go ahead and sit back one. Go ahead and sit back one. Thanks, Right now you're being detained. Positive canine alert on the video.
Thank you, Judge. The state's going to call Officer Daniels just for one.
One question? All right.
Other than foundation.
Is Officer Daniels here? Raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but? Yeah. Take a seat, sir. Make sure you speak into the microphone.
Good afternoon, officer. Can you please say your name for the record?
David Lyle Daniels.
And what's your rank?
I'm a deputy sheriff with the Okaloosa County Sheriff's Office.
How long have you been with Okaloosa County?
Just shy of 4 years.
On the video that you saw, it appeared that you were writing a ticket. Why did you stop writing that ticket?
To run security for Deputy Gonzalez for officer safety due to him focusing on his dog and not the subject in the car or the surrounding people around him.
Is there a policy that your department has regarding dog walks?
Yes.
And what is that policy?
That if there isn't another deputy there to assist with the security of the canine handler, that deputy that initiated would provide that security.
Okay, so that's the only reason you stopped?
Correct.
That's all I have.
Ross, Mr. Gilbert?
No questions, Your Honor.
All right, thank you, sir. You can sit down.
And the state rests, Judge.
All right. Any evidence from the defense?
No, Your Honor.
All right. All right, argument on the motion, Mr. Sprouse?
Judge, as you saw, the facts in this case differ greatly from Rodriguez. In Rodriguez, the officer detained the individual past the traffic stop in order to get the canine there to conduct the free air sniff. That's not what happened here. The officer was still in the middle of writing the ticket when Canine Officer Gonzalez arrived around 8 minutes after the stop and had to provide security for Officer Gonzalez. The issue with officer safety is, as the deputy stated, Officer Gonzalez is focused on the dog, not on the defendant. If something were to happen to Officer Gonzalez, now you have a dog that's a trained canine without a canine handler. So there has to be oversight. There's a policy. It's not like the state is coming up with officer safety on a whim. There is a policy in place for that reason. So the state would ask you to deny the defense's motion.
Mr. Gilbert?
Your Honor, a legal free air sniff consists of a police dog sniffing around a car during the course of a legal traffic stop. The driver's not being held for the free air sniff, they're being held for the traffic stop. The Supreme Court in Rodriguez versus U.S. has placed important guardrails on free air sniffs, establishing bright line rules that police may not prolong a traffic stop for a canine free air sniff without reasonable suspicion of another crime. and we rely heavily on Rodriguez in this argument. Rodriguez was driving in Nebraska when he was pulled over for driving on the shoulder of the road. The officer processed a ticket, and after his partner arrived, they continued to hold Rodriguez for a canine search. It's important to note that the canine was there the entire time because the officer that pulled over Rodriguez was a canine officer. So it wasn't a matter of when the dog arrived or how long or any of that. The dog was there at the initial stop. The search resulted in a conviction for trafficking charges. The Supreme Court reversed his conviction, holding that a traffic stop may not be prolonged beyond the traffic stop mission to conduct a free air sniff. Here, Mr. Robinson was pulled over for speeding. There was no other reasonable suspicion of a crime. The traffic stop deputy, Deputy Daniels, can be seen working on ticket-related activities. He meets Mr. Robinson, collects documents, returns to the car, and ultimately, the canine officer shows up. After the canine officer gives orders to Mr. Robinson, have him put his hands on the steering wheel and remain in place, he called Deputy Daniels out to pull security while he conducted free air sniff. This is undisputed. During this detour from his traffic mission, Deputy Daniels is seen providing security for the search. No traffic mission activity is observed after that point. Defense asserts that the traffic stop was prolonged by the canine search as the traffic mission deputy was detoured into the canine search mission. Quoting Rodriguez at 356, down towards the bottom, the government's opposite.
Hold on a second.
Yes, sir.
I must have a different, the Supreme Court, well, hold on a second. I'm looking at it. I just want to get back to Rodriguez because I was looking at some cases citing Rodriguez. Give me just 1 minute. 356, you said?
Yes, Your Honor.
All right, go ahead.
The government's officer safety interest stems from the mission of the traffic stop itself. Traffic stops are especially fraught with danger to police officers, so an officer may need to take certain negligibly burdensome precautions in order to complete his mission safely. On-scene investigation into other crimes, however, deters from that mission. So too do safety precautions taken in order to facilitate such detours. Thus, and this is still quoting, thus even assuming that the imposition here was no more intrusive than an exit order in MIMS, the dog sniff could not be justified on the same basis. Again, still quoting, highway and officer safety interests are different in kind from the government's endeavor to detect crime in general or drug trafficking in particular. This is a direct rejection of the state's argument today that officer safety for the canine search somehow mitigates the wrong of prolonging the stop. The Supreme Court says no. The legitimate officer safety concern stems from the traffic stop and the traffic stop mission only, not in the government's endeavor to detect other crimes through a canine free air sniff. The state also seems to put some weight on the timing of the canine search versus the completion of a ticket. Well, of course, the court addresses this too. Quoting, the critical question then is not whether the dog sniff occurs before or after the officer issues a ticket, as Justice Alito supposes, but whether conducting the sniff prolongs, i.e. adds time to the stop. In Mr. Robinson's case, the traffic stop was prolonged for the time the traffic mission officer, Deputy Daniels, detoured to pulling security for the canine search. The Supreme Court says unequivocally that an unconstitutional detour away from the lawful traffic stop and the prolonging of that stop for that detour for investigation into other possible crimes is not allowed. Defense respectfully requests that the result of the canine search and its derivatives be suppressed against use from Mr. Robinson.
Mr. Sprouse, anything else?
The state would assert that the investigation into Mr. Robinson did not occur until after the canine alerted. That a dog sniff is not a search. If the dog didn't alert to the car, we wouldn't be here today, but the dog did alert. The delay of walking the dog around the car happened before the traffic stop. Before the traffic stop was completed. On page 350, it says, this case in the Rodriguez case. This case presents the question whether the Fourth Amendment tolerates a dog sniff conducted after completion of a stop. So that's like the call to the question. Answer to that call to the question is we hold that a police stop exceeding the time needed to handle the matter for which the stop was made violates the Constitution's shield against unreasonable seizures. Judge, this is not a violation of the defendant's rights. He was lawfully stopped at a traffic stop. K-9 alerted in the middle of the traffic stop. Different than Rodriguez. The case doesn't apply. The state maintains its position that this motion should be denied.
Give me a second. Well, I think the facts are important as to the Rodriguez case, so let me just cite a couple of things that are in that case. Starting at page 352, Struble, who is the officer, returned to Rodriguez's vehicle a third time to issue the written warning. By 12:27 or 12:28 a.m., Struble had finished explaining the warning to Rodriguez and had given back to Rodriguez and Pullman, who was the passenger, the documents obtained from them. As Struble later identified at that point, Rodriguez and Pullman had all of their documents back. This is a quote from the officer. Had all of their documents back and a copy of the written warning. I got all the reasons for the stop out of the way, took care of all the business. Nevertheless, Struble did not consider Rodriguez free to leave, although the justification for the stop was, quote, out of the way. Struble asked for permission to walk the dog around Rodriguez's vehicle. Rodriguez said no. Struble then instructed Rodriguez to turn off the ignition, exit the vehicle, and stand in front of the patrol car. I think these facts are very different, Mr. Gilbert, as far as the initial officer who made the stop, who had the K-9, pulled him over, completed everything he was supposed to do, and admitted he completed everything he was supposed to do under the traffic stop, said it was all business was done or out of the way, and then asks if he can walk the dog around his car. Also different here. Rodriguez says no. He should be at that point free to leave based on all the case law in this particular area that I've read in the past. But then he instructs him to get out of the car, turn off the ignition, and stand in front of the patrol car to wait for a second officer. Go ahead, Mr. Gilbert, if you've got a response.
Well, I believe that the second officer had arrived. That is true that they waited for a second officer. The point, Your Honor, is there's a mission here. There's a traffic ticket mission, which is legitimate. It's the only legitimate reason that the defendant is being held. As soon as that is no longer happening, and the court says it doesn't matter if the traffic ticket is ended, it doesn't matter if the ticket's been given yet, it matters if the stop is prolonged due to a detour, and it uses that word, into another mission, crime detection, and it says specifically that a dog sniffed cannot be considered as part of a traffic stop. It's a separate thing. It is a search for evidence by the police, which comes with all the protections. So the traffic stop, being the only legitimate reason holding the defendant, is critical, because as soon as that traffic stop mission officer diverts from that mission and goes over into providing security for the canine search, and Rodriguez right on point on this.
The facts are very different, Mr. Gilbert.
It discusses exactly this, Your Honor, moving from the traffic mission to the.
But in this case, as actually pointed out by Mr. Sprouse, but I've read in the case, where does it go? I just highlighted it, now it's disappeared. This case presents the question whether the Fourth Amendment tolerates a dog sniff conducted after completion of a traffic stop.
No further traffic stop mission was done after Deputy Daniels exited that vehicle. He had converted strictly over to the K-9 security mission. He was no longer doing a traffic stop. He did no more activity after that towards the traffic mission.
Once he's taken out of the vehicle, isn't that the end of the analysis?
No, Your Honor.
I disagree.
The only thing, well, I understand, and I just would like to address it.
Well, here's the thing. You're certainly can make all the argument you want, Mr. Gilbert. What I don't have is a case on point, because these are very different facts.
So the first piece,
and I'll point out that Rodriguez, according to my Westlaw, has over 10,000 citing references, but neither side has brought any other case about any better facts that would tell me how I should decide that.
So in fairness, I believe in my motion, I cited the 2 DCA cases that have already come.
Let's talk about those then.
So one, they quickly said doesn't apply because there was reasonable suspicion. The person was acting very nervously. As soon as they had him, he was trying to hide something. As soon as they moved him, they found a gun. Beecher goes into talking about minutes later because in that case, the court could find the traffic mission had ended. They could not articulate in Beecher that there was any more traffic mission related activities occurring after that point. That's the critical point, Your Honor. It's the critical concept here because that traffic mission is the only reason keeping that guy there. And if the police,
until he's taken out and put into handcuffs for a different reason.
That's right. That's exactly right. As soon as you have reasonable suspicion of something else, but you can't get that through a K-9 search inserted into the middle or delaying the traffic mission.
The analysis ends at the time that they ask him out of the car. I think that's pretty clear.
On the arrest? The whole point is whether or not they can do the K-9 search, Your Honor.
But the K-9 search is over. The dog is already hit on the car, and they're taking him out of it due to the fact they're now going to do a different mission, which is search the car based on the reasonable suspicion given by the dog.
No, Your Honor. The different mission, I believe, and I would ask the court to look at specifically in the cited quote, was they said no. What happened was they drifted from the traffic stop mission into other investigatory things looking for crime. In this case, they're looking for drug trafficking and all that. In that very paragraph, it goes to the end and says that's not allowed because that isn't part of the traffic mission at all. And a dog search cannot be used.
All right, Mr. Sprouse, any other further response?
So the state of Florida has interest in making sure contraband is not being transported on the thoroughfare. So contraband being in a vehicle is still a traffic mission. That's why during the traffic stop, the K-9 walked around the vehicle. That's the purpose of a K-9 walk, is for contraband.
But what his point is if Daniels was sitting in the car, right?
Yes.
If Daniels continues in the car writing the ticket, then there's no issue. But once he exits the car, he's stopped that
traffic mission.
Writing the citation.
Understood.
In order to do something that's unrelated to the traffic stop, right?
That is the argument, yes.
And again, I point to the exact wording from Rodriguez. Even assuming the imposition here is no more intrusive than an exit order, such as because the whole reason for Rodriguez was that the Eighth Circuit had cases saying, hey, as long as the dog arrives at a certain few minutes after, Or it's no big deal if we have them stay a little longer, because it's just a de minimis intrusion on the defendant's rights. And when the court shut that down, they were using Rodriguez to shut down all these other courts, finding that the MIMS exception, which allows some officer freedom to control the scene, was somehow being expanded into this open-ended, oh, you can bring a search in, you can have the dogs do whatever. No, they shut that down. There's a traffic stop mission. They're expressly saying the police interest isn't in policing drug trafficking, it's in controlling traffic flow. For instance, in Rodriguez even mentioned the reason for calling back for warrants isn't to find out if the guy needs to be arrested right now, it's to find out if there's additional traffic violations. It's a traffic mission specifically, and once the officer ceases doing that, there's no reason why Mr. Robinson was still being detained. But he was.
If he had continued writing the citation, would he have been done before the dog sniff alerted?
If he had continued writing this citation, I have no argument, Your Honor. Okay. Because that's the continuation of the traffic mission, and that would be the
Well, the whole issue as to why the Supreme Court has found that this is unconstitutional is delays, right? You can't keep someone on the road for an indeterminate amount of time in order to investigate someone without reasonable suspicion.
Right. Well, it's a little more than delay. It's also, what are you doing? So in this case, it really is a traffic mission. They talk expressly about this traffic mission not being an investigation into other crimes unless there's reasonable suspicion. As soon as now all the cases you'll see out there that they turn quickly is when there's reasonable suspicion immediately found. Once that happens, Rodriguez goes out the window. But until there's reasonable suspicion, Rodriguez applies, which means you cannot delay, prolong, or detour from the traffic stop mission into the criminal activity evidence-seeking action, which is what the canine search is.
I think what the defense is proposing is that in order for a canine search to occur, there has to be reasonable suspicion. That's just not what the law is, Judge.
Not at all what I'm arguing.
Hold on just a second. Let me finish reading this Beecher case. Right, the Beecher case, and in all candor, I'm familiar with it. I was just making sure it was the same one that I thought it was, frankly, because the appellant's lawyer is a good friend of mine. And so I read this case. It comes out of Panama City, I believe. Yes, Bay County. And in that case, I think this is the important part. There was no evidence that additional activities furthering the lawful purpose of the traffic stop took place after 2:32 p.m. The canine didn't arrive until 2:40. So, hold on.
Yes, sir.
The issue, again, I'm not saying there's not a case that talks about something more similar to this, Mr. Gilbert. What I'm saying is no one's given me one.
Right.
And so this is what I'm going to do. I'm going to give y'all until Monday afternoon at 12 o'clock to supply me with any other case law you'd like me to review before I make my decision. Because I would just about guarantee there's got to be a closer set of facts than these. Because I'm well versed in the facts of the Beecher case, and that they stopped and then waited and waited and waited and waited for the canine officer to even show up. And it wasn't until at least 4 more minutes after that, until there was another issue.
Much less of a, absolutely, I get it.
So I'm going to allow for either side to, by Monday at noon, to send me any sort of other case law that's more directly on point, because frankly, U.S. Supreme Court cases are great because they really spell out the issues. However, if the facts are off, even a little bit, they're not exactly on point as we might want them to be. That case has been cited 10,000 times across the country, I'm sure. But in my brief research while the case has been going on today. I've seen several cases from Florida. I can't go reading through them because I want to make sure I'm paying attention to the arguments and the evidence. However, I'll give you a chance to send me anything else you'd like me to review that's more specific as to someone abandoning the citation, as you're arguing, Mr. Gilbert, in order to do something effort. But I think one of the important parts is that only went on for about a minute. And unreasonable delay is typically the issue that's talked about in most of these cases. And I'll also point out factually that it was Mr. Robinson's, number one, not having registration for the vehicle, not having the insurance for the vehicle, and admitting to the officer that his address on his driver's license was not correct, which is also a citable offense. So, Mr. Robinson, I don't need all the facial reactions every time I finish a sentence, okay? You're right behind your attorney's shoulder. I can see it nonstop, so please. Thank you. And in fact, the officer got out of the car to ask him, are you sure about that zip code? Because it didn't seem to be right, which further delayed his writing the citation because he was giving him the benefit of the doubt, where he could have said, sir, your driver's license isn't correct. You have 10 days to change that. But that's what further delayed some things as well. So I'm pointing that out because it's part of the thought process I have right now. And so I want to make sure I throw that out to you. So if you want to research anything else, you can provide anything on that too. All right. And that's for both sides, obviously, to supply me with any other case law. It's a very interesting issue. And I think the nuance is what's important. And so there's got to be a case that more clearly addresses that nuance than the very general issue of this Rodriguez case, because I think the facts of Rodriguez are very different. And so that's why I want to make sure that y'all have an opportunity to give me anything you want that's case law that's closer in facts. But
thank you,
so
Judge.
I'll give you until Monday at noon. Just send it directly to my office, or you can file it with the court. Just make sure you send a copy to me no matter how you file it. That way I can actually read it, and I want to make a decision because, again, everything's kind of fresh in my mind. Part of me wants to say give it to me by tomorrow, but that's not fair. So give it to me by Monday at noon, and then I'll take a look at it.
Thank you
very much, Sean.
Otherwise, I'll take it under advisement.
We'll see.
Thank you. Oh, Mr. Sprouse, can you provide the disc that's been admitted?
Absolutely. May I approach?
States one, yes, approach the clerk, please. All right, Mr. Keach. James Terrell, he's here on 21 CF 924, 21 CF 1577. And Mr. Owens, your case will be next, not because you went and sat in Mr. Keach's seat right in front of me, but because alphabetically you're next. It's not a bad idea to sit right in the front where I can see you.
Where would you like us, Judge? Tables, podium? I think we're kind of here on the court's own motion.
Well, it's not my own motion. Someone sent something in, but I think anytime it's addressed, I want to make sure it's brought up. Because I think even though Mr. Terrell didn't file this himself, there's case law, and I think we'll talk about it later, that the failure to do a Nelson hearing is per se reversible. Did anybody file the final competency evaluation in this case? Trying to pull it up and now I can't find it.
Which I'll log on and look. It's been a minute. $220. Maybe that's it. It's filed in one case and not the other. Got it. All right, I've got it now. Thank you. It just wasn't in the other case. I assumed it would have been in both. All right. We're here in two cases. Again, it's going to be 21 CF 924, 21 CF 1577. We're here due to the filing of correspondence in the court regarding a concern about what I determined to be a Nelson inquiry. Mr. Terrell, can you hear me okay? Can you move the monitor away? Mr. Terrell, can you hear me okay? Okay. Mr. Terrell, you're here because there's concerns as to whether or not you're... Can you... I've got it, thanks. Can you push that microphone down so his voice will be picked up? All right. Mr. Terrell, there's concerns about whether or not your lawyer is being effective for you. Is there anything that you want to tell me about that?
I don't have anything. I don't know.
What you said is, I don't have anything and I don't know.
All
right. Anything else you'd like to tell me, Mr. Terrell? All right. I just want to make sure I'm putting this on the record. And the court's already made these previous findings, but based on Dr. McDonald's previous opinion that's been accepted by the court, that her previous conclusion is there's opinion of the undersigned that Mr. Terrell is actively malingering by feigning cognitive impairment to avoid prosecution. There's no medical evidence to support a diagnosis of a neurocognitive condition that would render him as impaired as he is presenting himself to be. And recent information provided for review offered stronger arguments that he is, in fact, much more capable mentally and physically than he is revealing to those involved in the legal process. Is there anything else you want to tell me about your lawyer and if he's not doing something for you, Mr. Terrell?
I don't have no paperwork. I don't.
What paperwork do you need, Mr. Terrell?
with everything, with everything on it, I need.
All right, at this time, the court's concluded its Nelson inquiry. Mr. Keach?
I just want to make sure will indulge me.
Sure.
I noticed that the person who filed the Nelson hearing request is here in court, as well as Mr. Terrell's wife.
Okay.
I mean, if the court will allow us, and it will take up more time, but this is kind of a sensitive issue since we're proceeding to trial, if he would like to call those two people to the stand, since they're the persons who have filed the correspondence with the court, then the state and I could inquire of them as to what their concerns are, just to sort of perfecting the record since he's, but I'll defer to the court on its own calendar. If Mrs. Terrell is here, if she would like to take the stand, and Ms. Basso can cross-examine her, and I can question of her about what they believe is deficient, or...
All right, so is Mr. Pilgrim here? Mr. Pilgrim, do you want to take the stand? Come on up. Right hand. You swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth. Speaking to the microphone. Mr. Keach, do you have questions for Mr. Pilgrim?
Mr. Pilgrim, have you had direct conversations with Mr. Terrell?
Over the years, I have.
In the past 6 months, have you had direct conversations with him?
So I'm not sure the date, but I tried talking with him when he was released at home.
Okay. So, I mean, you filed a request for a Nelson hearing. Is that my understanding?
Yes, sir, I did.
What did Mr. Terrell convey to you?
So
Regarding, so that you could file that with the court is my question.
yeah. So the brief conversations that we have, along with what his wife has said, is that you have told her that he's guilty.
I'm asking you, what has he conveyed to you is my question.
Yeah, I don't recall exactly. It's been months ago.
Has he communicated with you since you were he's been repositioned back in the Okaloosa County Jail?
I have had no verbal contact with him.
Have you had the ability to text with him over the communication at the jail?
So I did try to do that, but I have not texted anything to him.
Your testimony today is that you've sent no text with him through the jail technology.
That is exactly what I'm saying. And if I had, it was, I don't know how in the world it went through because I haven't had any conversation with him through text.
Have you had any conversation? So since he was reincarcerated, have you had any conversations with him at all?
Yes.
When?
Yeah, I don't recall.
But since he was placed back in the jail?
I believe so.
So does he have the ability to communicate is my question.
So that's a good question. I do believe he has dementia of some sort. I have background in dementia and Alzheimer's.
Are you a physician, sir?
It's also non-responsive.
I work for a developer.
Are you a physician, sir?
No, sir, I'm not, but we
Objection was sustained.
develop memory care facilities for dementia and Alzheimer patients.
Are you
I was in one today before I got here.
All right, sir, you haven't been asked a question. Go ahead, Mr. Keach.
Were you with him when he was out of custody?
I did go to visit him a couple times, yes, sir.
To the best of your knowledge, did he ever attend any doctor's appointments or anything related to that to be diagnosed with his dementia? Based on what you know.
Correct. No, he did not.
Okay, thank you. No further questions.
Ms. Basso, questions for Mr. Pilgrim? Just make sure you get to a microphone.
Mr. Pilgrim, I just want to be sure, you filed a motion for Nelson hearing on behalf of Mr. Terrell, yet
Correct.
today you're not able to convey anything that he ever told you concerning his attorney or anything he ever shared with you. You've told us you haven't talked to him. You've told us that you haven't texted with him. So there's really no basis for that motion, is there, sir?
There is, yes, sir. He had mentioned that he didn't think that,
He had, excuse me, sir, you just got done telling us you had not spoken to him about it and you had not texted him, and now you're telling us he did
yeah,
mention
I
it to
believe
you?
I said I don't recall exactly.
Roughly when was that, sir? Was he in the jail?
No, he was not.
He was at his home?
He was.
And he mentioned concerns about his attorney?
Best I can recall, yes.
But you can't really recall what was said based on what you testified to today?
Yeah, I tried having a lot of conversations with Jim.
Your Honor, if that...
Any other questions for him?
Not for this witness, no.
All right, you can take your seat, Mr. Cook.
Okay.
Any other witnesses?
Judge, I called Mrs. Glenda Terrell.
Terrell? Raise your right hand, ma'am. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Sure.
Speak into the microphone, please. Go ahead, Mr.
Mrs. Terrell, you're the wife of Mr. Terrell, correct?
Yes.
Okay. And have you had the ability to communicate with Mr. Terrell at the jail?
We used to.
Since he was incarcerated this last time?
Well, this
have
last
you had the
time,
ability to speak with him?
There's somebody in there that knows him, that knows a friend of mine. So I was able to find out how he was doing, because nobody will let me know when I call the jail. I'm not allowed to see him or visit him or anything, so
My question.
I understand what you
Well,
said, and I just told you, there's a friend.
Well, listen to me carefully.
What?
Listen to me. Have you had the opportunity to speak with your husband on the telephone at the jail at any point in time since he was incarcerated?
Would you use your microphone? I can't hardly hear you.
Since your husband his bond was revoked and he was incarcerated, have you spoken with him?
No.
On the telephone?
No.
At the jail?
No.
Is it your testimony today while you're under oath that at no point in time you've had telephone conversations with your husband at the jail?
Not my husband. Well, you can look at her like that, but not my husband. He's got a friend in there.
Has your husband written you letters from the
What
jail?
now?
Has your husband written you letters from the jail to you?
Before,
No, this most recent time.
Mr. Keith, when he got arrested back this last time, I was so concerned because I wasn't hearing from him. I even told you that. I
That's, ma'am,
wasn't
my
hearing
question.
from him.
Hold on.
I understand, no.
Ma'am, answer his question.
My question to you, it's a very simple question. Has he written you any letters from the jail?
I don't recall.
You don't recall?
No, you want me to be truthful? I don't recall.
All right, I do want you to be true.
I don't
That's
recall.
the only thing I think any of us are asking of you today, honestly. And so I'll ask the question again one more time. Have you spoken with him on the telephone, whether it's through his account or someone else's account, since he was most recently reincarcerated?
No.
Okay. So if you haven't spoken with him, and I just want to perfect the record as it relates to the Nelson hearing, he has not then communicated with you any concerns?
Mr. Keith, I'm having trouble hearing you. I'm sorry, I don't hear real good.
Just fine.
Since
Can you turn it up just a little bit?
I can speak louder, certainly.
I do, because I can't hear very well.
Since your testimony is that he has never called you or spoken with you on the phone, and you also do not recall any letters being sent to you, what is the specific allegation that Mr. Terrell has made regarding my conduct as a member of the Florida Bar that leads me to be deficient? that he
Okay.
has communicated to you.
Okay, you want me to be honest about everything? Okay. Every time I spoke with you, Mr. Key.
I'm not about what I've said, what he has said to you.
Well, I'm going by what you've said to me. That's why
My question is, what has he communicated to you?
what the friend has communicated to me, I need to make this clear. You're not understanding me, I guess. He has a friend in there. I don't talk to Jim or anything. I don't get to find out how Jim is. So the thing about his friend has called me and talked to me, but Jim hasn't.
Is it your testimony that you didn't speak to Jim on December 25th of 2025 on Christmas Day?
No, Christmas Day?
Yes, ma'am.
Not that I recall.
What about December 27th?
No, because I was so upset because he hadn't called me in so long. I thought maybe he hated me now.
Okay, you are aware that all the jail calls are recorded, correct?
Well, sure, but I don't recall that.
Okay.
And I had a birthday on the 23rd. I didn't hear from him then either.
Okay. I have nothing further, Judge.
I'd like to say something else, sir. Can I?
No, ma'am. This is how this works. You're asked questions by the lawyers.
So, Mrs. Terrell,
Yes, ma'am.
I'm going to show you what I'm going to mark as State's Exhibit number 1 at this time. Mr.
Can
Keeter
you
previously shared this with
speak
you.
up?
Stipulate without objection.
Your Honor. Along with that, Your Honor, I'm going to offer States 2, because that is an excerpt from this.
Stipulate without objection.
So the states one is a letter. 1, 2, 3. There's 6 pages, 4 pages of the letter. One is an envelope, and one seems to be maybe the backside of the envelope. Be admitted without objection as states 1.
And then this is States 2. Certification of that disc is also included.
Okay. This is states 2. Any objection?
None.
That'll be admitted as states 2. Let me just get it marked.
Yes, Your Honor. And for the record, Your Honor, these were previously provided to me.
How do you work it? How do you put this on my ear? Just hook it on my ear. Is it gonna mess up my earring? Hold it like that, okay. Okay, but I just don't hear good anymore.
This will get really loud for you.
Okay. Thank you.
Court's reviewed State's Exhibit 1. Did you need this back?
I'll take them.
Have y'all marked that? It's on the other, okay. The back of the disc. All right.
May I approach the witness, Your Honor?
Yes.
So, Ms. Terrell, I'm asking you to look at State's Exhibit number 1. So you're saying you've never seen this letter in which he provided passwords and additional information concerning possibly bribing a witness as well?
No. Was this mailed to me?
Yes, ma'am. The envelope's right there.
Well, I
Go
didn't
ahead and
get-
flip through it.
I didn't get it. I have not seen this before. Let me read it out. No, I don't know anything about this letter. Why didn't I get it?
It's addressed to you, and it says it went to you, so.
Well,
Go ahead, take it.
I have not seen that letter.
And, Your Honor,
I can't,
Exhibit number 1, which is the letter in which Mr. Terrell does share with Ms. Glenda Terrell passwords, which clearly show that he can remember and can participate in his own defense. Additionally, Your Honor, he discusses making sure that a witness manages to forget their testimony in exchange for $25,000. It does show to the court that Mr. Terrell is able to convey thoughts and basically calculate and plan, nothing like what he's showing here. And it also goes to show that Mrs. Terrell is being less than truthful with the court about her communications with Mr. Terrell. I do also have State's Exhibit number 2, which basically are the logs and text messages and phone calls and any mail that occurred concerning Mr. Terrell. And this also contains the jail calls that Mr. Keith was referring to, along with any text messages. So it does show that, again, Mr. Terrell is being less than truthful with the court, and we do offer that for impeachment purposes, and also to show that Mr. Terrell is certainly more capable than he is asking the court to believe with his actions here today.
Any further questions for Ms. Terrell?
no,
Yes, sir.
can I ask a question?
You cannot ask questions of me.
Not from the state, Your Honor. Thank you.
Any from Mr. Keach?
No, Your Honor.
Step down, ma'am.
That's not fair. I can't ask him a question.
No, you can't, ma'am. It's time to step down and go back to the gallery.
Any other evidence for purposes of the Nelson inquiry?
No, Your Honor, on that issue. I do believe that the original reason we were here was the concern about his ability to communicate and/or participate at the trial that is previously or currently scheduled in March.
Mr. Terrell, if there's anything you have to say regarding why we're here, you're free to do so.
And somebody said I can fire him. Can I?
For what reason, sir?
I I don't have anything to look at. I don't. Can't remember everything. I gotta.
Court's conducted its Nelson inquiry and finds that Mr. Keach has not been ineffective in any way. We're set for February 25th at 9 o'clock for pretrial conference. I believe the case is to be set for trial in March. Thank you.
Concludes my business, Your Honor. May be excused today.
Yes. Thank you, Mr. Keach. We're going to take about a 5-minute recess.
hearing.
I've reviewed the motion for Nelson here, and
And
that's the first thing that we have to address, because a request for a motion or a motion for a new trial and certainly sentencing are critical stages
Yes,
in your
sir.
case. So I have to make sure that you have conflict-free counsel. You have a right to counsel at those, and when you have a right to counsel, you have a right to conflict-free counsel. So what I'm trying to determine is there some reason y'all have a conflict? What you're basically telling me is it's because he's not doing a good job for my case. That's our conflict.
I mean,
You
basically,
can address all these things. Even if I say now, I don't think there's any ineffective assistance at this point. That can still be pursued as, after your direct appeal, you can still do those things. I'm not trying to give you advice. I'm just trying to, this is not the end-all be-all hearing on ineffective assistance claims potentially. I'm just trying to determine if there's a reason why Mr. Riasti can't continue to represent you based on what you tell me throughout the rest of the motion for new trial as well as the sentencing, if I don't grant the motion for new trial, obviously. So what else do you think he did during the course of the trial? Because here's the big thing, and I think this is brought up at some point. The Nelson case talks about making that request before trial has commenced. Now, you can talk about what you could have done back then if he refused to do things at the trial, but I don't really want to get into what he should have done a year ago in your mind now, because we're kind of past that stage, unless you want to bring that up during your
my
post-conviction
biggest
issues.
Sorry, Your Honor.
Go ahead. No, go ahead.
My biggest issue and concern was with Calvin Daugherty. I pushed him relevantly several times to investigate Calvin Daugherty and his testimony and to subpoena him. And my best understanding that he was coming, that he was subpoenaed. And then the day of my trial, I'm like, "Where's Calvin?" I called him. He said he's not coming. And then he also made a comment that the state told him that they tried to contact him and he wasn't coming. But it's not up to the state to subpoena my witnesses, obviously. So that's where I found it ineffective.
Okay.
That was a potential.
And what do you think, Mr. Daugherty? Not specifics, but in general, what would he have testified to that would have changed your case?
A lot, everything.
Well, that's.
I mean, I don't want to get into details,
Okay.
but as you go on and review the stuff that he emailed you, the new discovered evidence.
I don't read emails from lawyers like that. I don't know what's been filed.
Well, he filed it. I guess he's.
But I have to address this part first. I'm not going into motions for new trial until I determine if you're going to do that with Mr. Riasti or potentially a different lawyer. That's not what we're here for today.
Well, he had pretty critical testimony and evidence pertaining to his encounters with the alleged victim and Amanda Wheeler. That would have, definitely gave my trial a different outcome.
Your Honor, Mr. Daugherty was not present for any of the issues that with regard to the actual events leading up to the shooting. So his involvement, or his testimony, that potential testimony is solely in the realm of he could have countered or impeached the testimony that was given by those witnesses that I've previously mentioned with regard to the Williams Rule issues. And there was, I was reticent, and again, I'll state that I was reticent to call Mr. Daugherty in the fact that he was actively suing my client, and also the substance of the text messages between them seemed to indicate that he believed that Mr. Douglas was guilty of the crime, and he was and the state could have one of the reasons.
Let me ask, was he ever deposed?
He was not deposed, no.
Was he ever talked to?
I remember having, I want to say, an email conversation. I don't think I ever spoke to him on the telephone. But my reticence to call him had mainly to do with the fact that he had significant text message communication between him, and that was the reasons why the state wanted to introduce him as a witness, because they were trying to portray Mr. Doherty's hiding for a significant time after the shooting.
Mr. Douglas.
Mr. Douglas, I'm sorry. Mr. Douglas is hiding for significant time after the shooting and subsequent trip into Walton County, and then his arrest in Alabama in a light not favorable to my client. And I believe that Mr. Doherty could have been a witness that moved the state along in that regard.
We have opened the door to some of those
Yes, Your
things
Honor.
that were not brought up. Specifically, I think I left out anything to do with how Mr. Douglas was found with the firearm, simply that he was found with it, because I didn't want that to be a situation that the jury might convict Mr. Douglas simply on things that happened after the fact.
Which was the subject of one of my motions in limine. So as even now, I believe that the benefits that Mr. Doherty might have provided with regard to the Williams rule were outweighed by and it was that reason why we discussed Mr. Douglas not testifying himself, because his argument as to what he did, which was he was going to testify, and I'm not going to go into that, but it was always Mr. Douglas's position that he wasn't there at the shooting, and that was presented via that text message, which was presented by the state without Mr. Douglas being there for cross-examination.
So it sounds like what you're saying is you got the benefit of Doherty testifying without the negatives.
Yes, that was my position. I believe that still was the best way to proceed in trial, given my post facto telephone calls with Mr. Doherty have since confirmed that.
Anything else, Mr. Douglas, as far as the Nelson hearing?
Again, I disagree with what Mr. Rossi is saying about Calvin Doherty's testimony. As Mr. Rossi knows as well as I know, because I just read the copies he gave me that Calvin just emailed him with all the testimony that he would have gave at trial, would have definitely been beneficial.
And that's the basis of the motion for a new trial, right?
I mean,
it's part of the basis for the motion for new trial. Yes, Your Honor.
Well, at this point, I don't see this as an issue that's a conflict between the two of you that's going to lead to where you're not getting proper counsel. It sounds like Mr. Rossi is almost continuing to investigate the issues and now wants to do this motion for a new trial based on those same issues. And again, Mr. Douglas, if it gets to that point, if I deny the motion for new trial and sentence you, you can still bring all these things as number one is your direct appeal on the issues that Mr. Rossi has brought up as far as the Williams rule things and the gun. And if there's a need to at that point after your direct appeal, you can still pursue a post-conviction issue such as ineffective assistance. I just don't think it's an issue enough that I've seen that this is not some strategic decision made by your lawyer. That's part of his side of it. That's why you have a lawyer, is to someone who knows evidence, someone who knows how to try a case, to make sure that you're not looking kind of blindly at the benefits of something without seeing the costs of it. And it sounds like Mr. Rossi has explained that to me sufficiently, that he got the benefit of getting that text message in that helped with virtually kind of your alibi without subjecting you to being potentially criticized by someone who was suing you at the time and may have provided testimony that was detrimental to you, that would have kind of overcome any benefit to you. So I think that's a strategic decision that lawyers are allowed to make during the course of a trial. as long as, the investigation's been done. Now, I don't know all the evidence y'all are talking about as far as newly discovered. We'll see what that is during the course of the motion for new trial, and then I'll make decisions on that based on what's presented during that hearing. But as far as the Nelson inquiry, I don't think you've shown me that there's so much of a conflict at this point, because we're not really talking about, I don't want to go to trial with my lawyer because I don't think he's doing what he's supposed to be doing. It's a little bit Monday morning quarterback, if you know what I mean by that.
I understand. I only consider it being a conflict, but like he explained to me yesterday, what I'm addressing is more of a 3850 issue.
Well, and which is I'm talking about is the post-conviction issue down the road. This is not ending that possibility. It's just, is there enough at this point for me to say, you know what, I think Mr. Riassi's done something improper in your case. I'm going to remove him from your case, bring in a new lawyer, and let that lawyer argue your motion for new trial. Because that would be, if I felt there was an issue there, that would be the remedy I'd have to give, is to bring in a completely new lawyer to say, argue the motion for new trial. It's not like a 3850 where it'd be, you get a new trial because of that.
Right.
The motion for new trial is all about these other issues that y'all have addressed in your particular motions.
Understand.
Okay. All right. So we can get that set. Are y'all ready to get that set for hearing?
Yes, Your Honor.
Now that we've got past this point?
There's no, I know of no reason why the motion for new trial can't be set.
All right. Ms. Leone, any reason why we couldn't set the motion for new trial?
Anytime the court
Okay.
allows it.
I kind of feel like I want to put it on the same date as Mr. Rolandi, just to, because I think it could take a while, is what I'm saying, and I don't want to put it in a situation, because I know February 26th, if we put it on that date, we're going to be here till 8 o'clock again. But I don't want to wait until March or later to do that if we don't have to. So,
Want to hold off setting it and then
well,
see if there's a date that the court.
let's do this. Let's set it for March 26th. Not March 26th. I don't know, that's one of our dates. That's the one I want. For February 26th. That's one of those weird things where, March has the same dates as February unless it's a leap year. February 26th at 9 o'clock is just a kind of a status to see about setting that for a hearing. Because again, I want to give you the full time that you guys are going to need, not try to put you at the end of a docket or put you in the middle of a docket where we're going to be here too long, and therefore people start to get to the point of, we don't have enough time to hear this. I want to make sure I give enough time. So why don't, in the meantime, Ms. Leone and Mr. Riassi, if y'all could talk about how long you think the hearing's going to take, and then we can talk about that on the February 26th date, and then get it set for a hearing at that point. I know that's 3 weeks away, but I don't have any other dates before then. Mr. Douglas, I'm going to be in a civil trial for the next 2 weeks, and then I get back into the kind of the criminal side again. So that's the next date I can give to you, but let's let them set it up now that I'm going to keep Mr. Riassi on your case based on what I've heard today. And then we'll have that hearing hopefully sometime in March. I just don't want to put you, I think that February 26th afternoon docket's pretty stacked up already. Unless, don't I have one March 5th? I just don't know if we've put much on that yet. Well, why don't we just, I only see one thing at 2 o'clock on March 5th.
March 5th, Thursday, 2 p.m.
Yes, my miscellaneous dates are Thursdays.
Scheduled on that date. And that's
The only thing I can see right now that's on March 5th at 2 o'clock is a motion to modify probation. So that sounds like a good landing spot. Can we do it that day?
What was the date you're on?
March 5th? I don't want to do too much that day because that's the day before jury review, and then we go right into jury trials right after that. So I have to be cognizant that I can't keep the lawyers here until 5 and 6 and 7 o'clock at night when they've got to prepare for their trial cases the next day. So I just don't want to be in a situation where I'm kind of burning everybody out, Mr. Douglas, just to kind of see behind the curtain as to the court's rationale. So I'd rather put it on the 5th, even though I want to keep that day light, because the 26th is kind of a mess already with the number of cases we've got. So, Ms. Leone, any issue with that?
No issues, Your Honor, I can do it.
All right, so Mr. Riasti, if you could do, now, which motion are we going forward on? Yours, Mr. Riasti?
Mine,
Okay.
but I was looking at the rules with regard to modifying motions for new trial, and they state specifically that if there's any modifications, that they should be done within the 10-day period.
Okay.
But it didn't mention whether or not the court would entertain adopting issues which were brought forward on a pro se motion for new trial.
Ms. Leone, any objection to him having, say, 5 days to amend his motion at this point? Just because they're not competing, but there was Mr. Douglas's that he filed, and there's Mr. Riasti's that he filed. I want to make sure we're hearing everything. I mean, he could certainly just adopt Mr. Douglas's, but I think maybe having an amended motion that kind of explains everything at once, instead of us going back and forth between two different motions.
Yes, Your Honor.
So I'll give you, let's just say until noon next Friday. So that would be the 13th. And then that way, there's still, 2+ weeks for them to prepare for that motion for a new trial.
No matter what, I'll file an amended motion, meld the two motions together.
Okay, perfect. All right, and then we'll hear it on March 5th at 2 o'clock.
2 p.m.
2 p.m.
Yes, sir.
I think he was responding to Ms. Leone.
I had a quick question.
I don't take it. It happens to me almost every day. Yes, Mr. Douglas.
I say it to my girlfriend a lot, so it's probably.
Just for
Yes,
clarification, we're not going to have a hearing on 226 anymore,
No,
just on the 5th.
just
Okay.
on the 5th.
Yes, thank you.
The 26th would have been just to kind of set a hearing once you know how much time you needed. But just remember, when people start asking for things on the 5th, that we don't put too many other cases on there, because there doesn't seem to be much there right now.
We'll remind you.
Until we get, 3 pretrial detention hearings that have to go that day, and they don't finish till 3 o'clock. So, all right, Mr. Douglas, you said you had another question?
Yeah, this is regarding Calvin Daugherty. Now, can he be present during my motion for new trial?
I'll let you talk to your lawyer about that.
Okay.
The answer is yes. I just want to be seen as encouraging or discouraging anything, and just, I'll let y'all talk about that.
Okay.
All right. Thank you, Mr. Douglas.
Thank you.
Thank you, Mr. Riasti.
That's all right. The answer is yes. He can be present. Your Honor, I have I don't know if you remember the Miles case. It's, anyways, there was
I don't remember it being on the docket.
It's not on the docket. I had filed a motion for J